RLMC, who directed appearance of both the parties. This quashing matter. Some or other it has skipped the date. Skip the date. Some or other could not be listed on the scheduled date. And I pray on Tuesday.
What are the offences?
Offences, my lord. So at your lordship has taken note of everything and the affidavit has already been filed. The lady is supposed to go Hyderabad, where she is staying after marriage on Wednesday. Can it be on Tuesday?
Could be Tuesday.
My lord. One criminal appeal 411/18. It was delisted. Last week it was delisted. Any shortage may kindly give us. Another matter, my lord, criminal division. Check box case. Conference already filed. And they have also filed. Maybe listed.
The memo will see.
Shorted matter.
Yes.
My lord, I am in BC, my lord. Your lordship may permit me to say, my lord. My lord.
Yes, yes.
My lord, actually, yesterday I do mention that CRLMC 1475 of 25 be listed earliest, my lord, because it is a vessel, cargo ship, my lord. It has to be maintained day by day.
Yesterday you mentioned, give the memo.
My lord, I have given the memo, but your lordship has directed it to be listed on 29th instead of Monday, my lord.
Monday may not be possible. It's not.
My lord, Tuesday, my lord, Tuesday.
Tuesday, this week. Very tough. You will have to wait unnecessary.
My lord, Tuesday, my lord.
No, it's not possible. Vessel is arrested. What is the big deal about it?
But my lord, now it has been permitted to vessel has to be released. My lord.
It's all right. Yes.
Vessel has to be released, my lord.
Yes. Yes.
May I be pardoned, my lord?
Yes.
I'm on BC. Yesterday, item 48 was to be taken up as first item. Though I am ready, but suddenly for something, I am leaving for Bombay for my wife's treatment. Can I pray, my lord, any day a week after? I am ready with the matter. That complaint matter, my lord, I have checked up.
That matter which your lordship practically had the matter yesterday completely. It is,
No, my lord, there are some confusion.
Fixed it for. There is absolutely nothing to say.
Confusion I am explaining, my lord. First of all, he filed a FIR.
There is, my lord,
another matter. 34. It may also be adjourned because I am suddenly leaving. So that is the whole difficulty.
On the goods.
Obliged.
I mentioned from item 1 to 4. I don't think I'm taking one check.
Lordship, matter is relating to the release of seized goods. Goods are kept
You are
in.
referring for whom? Which item? Huh?
Item.
Item?
Memo mention.
Memo mentions.
What?
Give the memo. Yes. Yes.
Items 5 to 12. Item 13 to 25. 15 minutes. Item 15.
On the questions.
My lords, item 25 may be granted a passover after the lunch.
Passover.
Lords, most obliged.
26 to 33. 35 to 41. I don't know. The informant and the active person both are present after the notice. Let the matter may be taken up.
What are the offences?
For compromise.
Offense.
Offense is the file
Take
affidavit.
it up. Yes. 2 p.m. 2 p.m. Yes.
42 to 47.
Number 47, madam. Here, madam, reading is complete. All reading is complete. I pray one time to prepare myself properly, madam.
Who you are appearing for whom?
I am for the petitioner.
Who is for opposition?
I am for the opposite. I have no objection.
My lord, here say he is not the opposite party 2 to 4. He is. The state is the one and only the workman is not getting the compensation because of the.
Are you opposing?
I am opposing lordship simply short date because.
Yes, opposing. Yes.
Interim order to control.
No. He is opposing. I'll hear it. Yes.
49. Also will take up this one.
I'll hear it in the its turn. Yes.
49 to 56.
Lordship, item 53 on behalf of Mr.
50?
Pahali. His wife was admitted to hospital
Sir,
today.
I have
So
objections,
that
sir.
I prefer next week.
On the last occasion, I have also objected, my lord.
But his wife is not.
His wife was
Yes,
admitted to.
on the last occasion, many times they have taken the health ground. I don't know.
He has
if-
medically
if-
instructed me.
But what can I, your brother is opposing personal ground. I
Last
guess
time, Lordship,
he is opposing. That's the problem. His personal difficulty.
No,
wife-
that's I understand, my lord, because there is the order that don't further adjournment to Ulada.
That's right, but now.
No, your lordship may fix a date next week.
yes,
my lord.
yes, Lordship.
Okay.
51. 51. Interim order.
Yes,
51, my lord. Can take up next week, my lord.
on the requested date,
Interim order.
51. Yes.
57 to 65.
64, my lord.
Yeah.
Next week, my lord. Here, state also to file the investigation
Request,
next week.
yes.
66 to 70.
My lord, 66, my lord. Next week, my lord.
My lord,
I have
68.
taken consent.
Yes, my lord, my learned senior Mr. Rao has already telephoned me. I am not objecting his adjournment. My lord, a short date because 138 proceeding has been stayed. It's a age-old proceeding.
Please go. Okay.
Interim order to continue.
Give it.
Any date suiting to my lord's convenience, but a short date, my lord, because stay is operating
Yes,
again.
I'll-
And the second case, there are two cases. Your lordship may kindly see in the second case, they have not filed the requisites for
I
issuance
will
of
file, my
notice.
lord. Unutilized copy. may
But
be
requisite,
sought.
you have taken stay, you don't file them.
No, no, my lord.
There are
Second
two
case,
proceedings.
only
I can get the.
annexures are some defect are. I will take by your lordship.
In the first
I will take.
One minute, whether in the second case, do you have a say?
Yes, my lord.
Then you have not filed the process.
I will file, my lord.
No, you will file. but
Only
wait.
annexures are not wrongly not given. You have filed. Annexures are not given. I will give.
1 minute,
Okay.
by order dated 3/3/2025, notice has been issued to the opposite party, and interim further proceeding in 160 case number 3197 of 2020, pending in the court of JMFC LR Bhubaneswar has been passed and was issued. The requisites have not been filed. Pursuant to the jail order. The legal counsel for the petitioner seeks 1 week time to file, 2 days time to file, 2 working days. To file
Yes,
the
ma'am.
requisites, let him do so. Subject to petitioner paying a cost of rupees 1,000 to the bar officials. Yes.
Interim order to continue, my
Yes,
lord.
do.
Both.
Please.
A short date suiting to my.
I'll give it. Yes.
Great.
Yes.
One.
When your lordship takes up the list.
That yesterday matter which I was doing, my lord's release. I have told my lords that bank guarantee, I have to furnish the entire amount to get a bank guarantee.
You move application. You have to move application because I have dictated in the. I find it. You move application, I'll just punch it. Yes. Yes. Yes.
Item 1, my lord, my friend is there for one of the petitioner. He will commence its submission thereafter.
Yes.
No. Question the. 2565, CRLMC 2565. Which has been filed for quashing the criminal proceeding.
Yes.
That matter may kindly be taken off fast
Yes.
because the other two matter are challenging the rejection of 205 applications. So this matter may be taken off fast so that here this is a case, my lord, where Parada Khemundi PS case was registered on 14/7/2021 for offence under section 302(125), 120B of the IPC. The deceased, the father of the deceased is the informant, registered the Parada Khemundi PS against 3 persons. The wife of the deceased, Wife of the deceased
Yes.
and DFO and cook of the DFO office. There were 3 persons, accused persons in Parala Community PS case
Yes.
number 141 of 2021,
Yes.
which was registered on 14/7/2021.
What are you seeking here?
My lord?
What are you seeking? Passing?
Yes, I am not in GR case. In Parala Community PS case, after completion of investigation by a team of investigating officer constituted by the state government, charge sheet was submitted under section 285 and 304A of IPC against me, Vidya Bharati, wife of the deceased. Cognizance was taken. I appeared and filed a 205 application. Against that, I have come 205. After submission of charge
You are
sheet,
the wife
after
of the deceased.
yes, after taking of cognizance, 1cc, a protest petition was filed. Your Lordship, have a glance to the protest petition filed by the informant as complainant.
Yes. Father of the deceased.
Yes, page starts from page 30.
30. Yes.
My lord, kindly bear with me. This is not a case of final report under section 169 of CRPC. Charge sheet was submitted under section 170. A protest petition was filed under Annex 4. Lordship, kindly see.
In this protest petition, cognizance is taken now.
My lord, I will kindly see. 1cc number such and such below that.
Yes.
Protest petition arising out of Parala Community PS case number 80 corresponding to GR case number such and such.
Yes.
And kindly see this there.
Yes.
At page 47.
47.
Well, got it.
Yes.
Therefore, the complainant prays that Your Honor may graciously be pleased to consider the facts stated in the complaint petition and may kindly direct for further investigation into the above pointed out lacunas under section 1738 of CRPC by a court appointed SIT to ensure that justice is served.
Yes.
This is a protest petition filed for further investigation by SIT. So, Lordship, kindly,
Initial statement recorded.
my lord, initial statement was recorded. Your Lordship, kindly have a glance to answer file.
Now, what is your point? You tell me.
But my respectful submission before Lordship would be, since it is not a case under section 169, not a final report. Protest
petition can't, he could not have filed.
Protest petition for further investigation cannot be treated as a complaint case, and in that complaint case, cognizance will be taken. This is my first link of submission. Your Lordship, have a glance to the.
Are you serious about the pleadings in a criminal case?
My lord?
Are you serious about the pleadings in a criminal
No, I am not in pleadings of the.
To be decided on the basis of pleadings.
My lord, I'll come to that. I'll come to that.
Prayer here and there, made
Yes.
an application. See the substantive case. It is a
Yes.
protest petition. Initial statement is recorded. You point out whether an offense is made out or not.
Exactly.
Only initial.
Exactly.
That's all.
I'll come to that.
Yes.
I'll come to that. Your Lordship, kindly see the contents of the complaint case.
Yes. Come to the merit.
Allegations or any prima facie materials are there against 302.
You show me that.
My lord, kindly see. The page 33, Lordship, have a glance to page 33.
3-3.
Fact of the case, my lord, starts from para 9.
Come to the relevant part.
But relevant, this is the only paragraph. Entire case is, this is the only paragraph.
Yes.
Your Lordship, kindly see the last sentence.
Yes.
The complainant along with his wife rushed to the Ashwini hospital in Cuttack and deceased was alive by that time. But subsequently, but last, my lord, I am placing that paragraph, last 4 lines. The complainant alleged that death of the deceased was jointly caused by DFO, wife of deceased and the cook.
Yes,
But death of the deceased was jointly caused by DFO.
yes.
What is the cause? Nowhere stated in the
And
complaint
the,
petition.
let us see the other contentions.
And other contents again kitchen I thought the status on Poyasle
investigation.
dead chat for again grounds Poyasle. This is the only case in the complaint petition.
Yes,
Now, there are grounds because they are prayer for further investigation, but this is the only allegation they have made in the complaint petition.
and the grounds were what they say.
The grounds, my lord, basic ingredients of charge sheet offense offenses are lacking. That means 285-304A, the ingredients are lacking, will say government's nelle.
Page 33I, you notice. That is the backgrounds.
Yes,
Enter case 33I. Enter complainant case
no,
is
no,
33I.
38 grounds also you see.
The grounds for that basic ingredients had been put to investigation. खाली दीटा ता पूर्व मु टिके खाली डेट चार्ट रे आपन खाली देखि दोछ लॉर्डशिप हैव अ ग्लांस टू डेट 14/8/2021
Yes.
that page 37 my lord have a glance to page 37 stanker डेट चार्ट तुम खाली दी तीनटा जिंस खाली मार्क कर
Yes.
page 37 14/8/2021 state government transferred the investigation of the case to a crime branch and state case was registered CID PS case number such and such. Next is 16/8/2021 team of 9 members of criminal branch visited the crime spot, recorded the statement of witnesses, interrogated DFO Sangram Kesabera and cook Manmat Pumba. 1/9/2021 crime branch recorded the statement of petitioner and his family members of Aguna village. Next 19/9/2021 polygraphy test of DFO Sangram Kesabera and cook Manmat Pumba was conducted at SFSL Bhubaneswar. Polygraphy test of Vidya Bharati Panda was also conducted at SFSL Bhubaneswar. Polygraph test report submitted by SFL to crime branch. Prior to that, there is a dying declaration.
What was the motive according to the complainant? What is the motive?
This is a case of accidental death. This is not a homicidal death, nor it is a suicidal death.
What is the complainant's case?
Complainant case, I got allegations. I have read this much of allegations. Even if I can 202 inquiry, your lordship kindly see the 202 inquiry. 4 witnesses have been examined. All 4 witnesses kindly see how they have what they have stated in their inquiry. Starting from equation of witness number 1. The accused persons are solely responsible for his death. The last sentence in all 4.
Yes.
All 4 have stated accused persons are solely responsible for his death.
Yes.
P.T. you also said accused persons are responsible for death. And kindly see the annexure 5.
Yes.
Annexure 5, after protest petition, a complaint petition under section 200 CRPC. It is not a complaint petition under section 200 CRPC. Learn code bill has indicated the first line. A complaint petition under section 200 CRPC is filed, arising out of Paradakhamdi PS case of such and such by the above-named complainant against the above-named accused persons for offence under section 302(120)B IPC through advocate such and such. I found that the same is duly executed, hence the same is accepted, register this case, put upon such and such for office note. Your Lordship, can the next page is important, is 58, order of cognizance.
58,
Yes, 58.
yes.
The case record is put up today for occurrence of necessary order for occurrence of necessary order in respect of cognizance. Learned counsel for the complainant is present and filed Hajira had perused the complaint petition, statement of complainant recorded under section 200 CRPC and evidence recorded under section 202 CRPC and other available materials on record. On my perusal, I found that there is a prima facie case is made out under section 302 120B IPC. Hence, cognizance of offence under section 302 120B of IPC is taken. This is a complaint case, not a GR case investigated by the investigating agency and filed a charge sheet and learned magistrate. Yes, I understand. Learned magistrate said, yes, I perused the record and prima facie matters there.
Yes.
Since it is a complaint case, some reason
Show me the initial statement.
that, my lord, will see the initial statement starts from page 32, starts from page 32 of my brief.
Yes. 32.
32 of my brief.
Yes.
May I read my
Yes, yes.
I am the complainant of this case. I filed this case against the accused persons. As per complaint petition serial number 2, I had one son, namely Soumyaranjan Mahapatra, who belongs to village Begunia under Baleswar district. On 1/6/2020, my son was posted as ACF and joined at Paralakhemandi. On 1/12/2020, he got married to accused number 1 and stayed in our house for about 1 month. Thereafter, he returned back to Paralakhemandi as he resided alone, and he was also reside in a very long distance. I told accused number 1 to accompany my son, but since their marriage, accused number 1 was not happy and making regular disturbances with my son. As they newly married, I thought it was common. At Paralakhemandi, accused number 2, being the senior officer, started to visit my son in the quarter. But subsequently, he only came and talked with accused number 1. My son also informed me so many times that he does not like the visit of accused number 2 to his quarter. And accused number 1
Come to page 50 and onwards. 50 onwards.
50.
49 onwards. This is 202.
This is the inquiry under section 202.
That's what I'm.
Yes.
Yes.
This is the
Any material.
may I read the entire
No, just relevant part.
kindly see the para 3, page 50.
Yes.
On the day of Rath Yatra, my sister called me that she received a call from the mother of accused number 1 that deceased was born and shifted to Barampur. So I tried to call accused number 1, but she does not respond. Then we made arrangement and came towards Barampur. Our village is situated at a distance of 30 kilometers from Bhadra. Whereas the in-laws house of deceased is at distance of 100 kilometers. But when they crossed Panikoli toll gate, they were also reached there, but had not gave any satisfactory answer to us. When we reached near Bhubaneswar, we again received a call that the deceased was shifted to Cuttack Medical. So we went to Cuttack. At about 7 p.m., deceased came. He was burnt in whole body, without any cloth, without oxygen or medical support. As there were no any facility at SCB, we shifted him to Ashwini Hospital, where he took his last breath. Before that, he tried to say something to me and other, but due to his injuries and swelling in throat, his voice was not understandable, and he cried. After the occurrence, the police personnel, as a senior officer of the deceased, had not properly corroborated.
Page 53, para 4.
53.
Para 4.
On 16/7/2021, we visited the quarter of deceased, but it was only locked and not sealed, and the keys are with accused number 2. When we went inside the house, the floor was clean, not a single article has been displaced. No any burnt marks or smoke marks found on the wall or roof of the factory. There are people and other articles were here, and there is plastic polythene, but all were as it is. Accused of 1 and 3 told everyone that they tried to rescue deceased by pouring water, but no mark of ash or water has been found. The deceased was murdered, and accused persons are solely responsible for his death. Everybody has said the accused persons are responsible.
There is
for
no
it.
direct evidence,
There is no, absolutely, there is no direct evidence.
but the circumstances,
Sorry,
there.
circumstances. There is no circumstances at all.
No, circumstances are there.
So far as
Circumstances
killing
are
of
there.
disease,
You say
killing
that,
of disease by these three
You
persons.
people say that it is a extent. We try to rescue him and put kerosene, water and all this thing. But in the house, there was nothing found. Not a single thing is upset.
That has been seized.
That's
If
what,
lordship
that
can
was
see
the
the
evidence.
report.
That is the evidence.
Yes,
Yes.
if your lordship will finally the
That's the
seizure
evidence.
report,
Yes.
all everything has been seized. Your lordship can see the charge sheet. From the charge sheet, my lord will find.
And now come to page 55, para 5.
After all the rituals, I along with the complainant and other family members visited the quarter of deceased spot and found surprise that trees were in active number 2 somewhere the bed. When you entered inside house, it was not looking like a place where person born from 9 Only ashes of small paper pieces were scattered on floor. There
Read it, read.
was everything at the house were including the plastic materials. Small paper pieces were scattered on the floor, whereas everyone at the house were in plastic material. Further got to know that when the deceased was shifted from Parada community in ambulance, accused Vidya Bharat Konda did not accompany him in the ambulance. Instead, she went in another car and ambulance waited for at least 20 to 30 minutes near Forest Gate for accused number 1 without any satisfactory reason. From such course of event, death of deceased did not appear to be normal or suicide, but a premeditated murder. The question of
The upward and forward conduct, post and pre-incident, is also relevant for the purpose of circumstances at the cognizance stage. What to do? It is only at cognizance stage. It only cognizance is taken.
Yes, cognizance taken under section 302. 302.
120B.
302, 120B. Well, there is no materials so far as 302 of IPC is concerned.
Have you read out 44?
That
53,
they responsible for death of the deceased. So allegations of all the accused persons are responsible for the death of the deceased.
There is no direct evidence. You are right. There is no direct
No,
evidence.
there is
at
no,
all.
all right, but there is no
But
direct
there are
evidence.
some circumstances
But-
which.
But the allegations is responsible.
Yes, who is appearing for the informant? You are appearing? Yes, tell me.
My lord, none of the allegations are circumstantial, my lord. In fact, there are circumstances that before the death of the deceased, in the charge sheet itself, there was dissension between the deceased and his wife, my lord, Vidya Bharati. There were some letters.
What was the relationship between the present petitioner and that DFO? Was there any relationship?
Senior.
Huh?
Senior, DFO SCF.
Sorry?
There was an extramarital affair between the DFO and Vidya Bharati.
Where is that material? Where from I get it?
Well, that is in the initial
Page-
statement of the.
Page 33,
30?
33, 1 man.
33 1. 33 1. Yes. 33 1.
My placement.
Yes.
Page 33 of
Yes.
I Jotach.
Yes, read it.
That is alleged that in the affair that is son of the complainant, deceased, had joined as a chef on 1/6/2020 at Parala Community Division and got married to
But
Vidya
the
Bharati
illicit
Konda.
relationship between his wife and
Mine.
the DFO.
Mine.
They threatened to kill him
Mine.
and pleaded before his father to somehow to transfer him from Barikada.
They want to lodge the affair. On the next day morning, they got information that he was burnt.
Also,
That is
there
the
are
case of the
discrepancies-
my lord complainant.
There are discrepancies in the statement of Vidya Bharati Konda itself before the in the Ashwini hospital, before the police, before the
Chain of circumstance, my lord, can I explain, my lord?
Hmm.
Because my lord and senior has first pointed out the protest petition. It is a protest petition. Protest petition is itself a complaint petition because it is filed under section 200. So cognizance was taken under section 19. So this is the prerogative of the magistrate on his own motion or on the police report or he can give to the police station for investigation. So once it is brought to the notice of the magistrate, my lord, he has think it proper to inquire himself, my lord, and he has inquired and cognizance was taken. So there is legally there is no bar because a prayer was not made, so cognizance was taken. Then, my lord, question arose whether 302 is made out or not, because police has submitted charge sheet under section 304A and 385. But the protest petition, your lordship will find.
Police also doesn't say that the incident had not
Taken
taken
place,
place at all.
my lord.
Police say that the incident has taken
Taken
but
place and
this
because of the
particular offense
negligence-
might be made out or may not be made out.
My lord.
Yes.
Then, my lord, 302, your lordship, case based on circumstantial evidence, there is no eyewitness to the occurrence. On the day of occurrence, my lord, I have brought your lordship's kind attention, page 33I. And it is clear that there was a illicit relationship between the DFO and this Vidya Bharat. Thereafter, my lord, when he intimated to her, his father, my lord, his father wanted to lodge affair on the next day. The next day, he got information that his son has been killed. Incident occurred at Parakhamni, my lord. Your lordship may kindly the conduct of the accused persons. He was not taken into hospital, nearest hospital. His father's house is only 33 kilometers. He has informed 100 kilometers his father is, because a person is born,
95.
immediately he needs some treatment, medical care. That was not done. Then he has brought to my lord Kotak, SCB hospital. Then when the father and other, there are private hospitals, he is SCF, my lord. So it can be treated as Bhubaneswar or elsewhere because he has come from Paralakhandi. When this petition, this is the allegation, I am not saying, my lord, this is the prosecution case. And he has come at SCB, when he come to the SCB medical, my lord, they came to know that there is no oxygen, there is no treatment, for which immediately this father and his relations, my lord, except the my lord wife or there is not there in the record, my lord, they have brought to the hospital. And so there he succumbed to injury. So
prior to the, bringing hospital, there was no treatment.
No, this is the, he was treated in there only at this is the prosecution case, he was only at the hospital medical box. There is no oxygen, there is no treatment. So this conduct indicates, my lord, so there is a prima facie case, they have committed the murder. Thereafter, then another thing, my lord, when they have gone to the house, my lord, they have not detected any burn symptom, my lord. And at the stage of, my lord, this is a very preliminary stage, and the only cognizance has been taken.
Yes.
But there are also discrepancies. They say that they try to pour water.
I need not go into all that. Yes. Yes, I'll pass you.
What my friend has stated, your lordship can listen. Entire thing, but without any record. My friend has made a statement without verifying the record. So lordship kindly see the statement of doctor who treated initial. More name of Kishore Chandra Behra, more LPR, more.
Where, which page you are thinking?
That will GRK's record matter.
Yes. Yes, are you?
Just,
Want to add anything?
I am not going to the factual aspect.
Kishore Chandra Behra statement.
Yes.
I am not going to the factual aspect. Just I am reminding my friend appearing on behalf of the state submitted that rightly cognizance has been taken on section 302, section 120B. Whether that aspect is correct or not, I will point out. The case was initially investigated into by the local police. Subsequently, since the deceased was a high-ranking officer, the government took a decision to transfer that case for investigation by the CID CB. So ultimately, charge sheet was submitted. Not that it is a case, completely final report was. And basing on the charge sheet, the Lord Magistrate took cognizance under offense on section 304A and another section. And there was only one accused. Now my friend says, I am asking my state government, whether you say that your investigation is incorrect, the finding is incorrect and probably wrong, and the complaint petition on basis of which cognizance was taken, which has been subject.
Whatever Mr. Jana has argued, he should have argued.
I have already.
Whatever Mr. Jana has argued, he should have argued.
No, they have not verified the record.
I am not arguing.
My friend has not verified the record.
Assisting, okay.
Yes, he has not verified the record.
just I am submitting. Your case is, your investigative finding is that it is a accidental burning resulting to death. That is the finding of the state government after due investigation. Now, the magistrate took cognizance, one incident. Now there are two cases. In one case is a GR case, other case is a complaint case. In one case, cognizance has already been taken prior to the taking cognizance in the 1/6 case, whether it is permissible under law. I will explain it is not. Why? The Code of Criminal Procedure itself is a complete code. Nobody will say that I failed to get justice in the system. That's why two provisions were added later on. Your Lordship may have a glance. This offence on which charge sheet was submitted, it is triable by magistrate if the trial will continue. Let us say that during course of trial, the magistrate.
319 can be invoked and all this.
Yes. And even there is another provision 319 and 323. Two provisions are there. Once the court has taken cognizance on the same self of occurrence, can the court take cognizance for the same self of occurrence for some other offences added the accused?
Show me any judgment.
That is the question.
Show me any judgment.
Yes, yes. I will cite the judgment. Once
file written note.
Yes. Once cognizance was taken.
I understand.
That is the legal point. Now I am coming to the other aspect. The law and court of my friend Mr. Pradhan, while drawing the attention, said that what are the material before the magistrate to come to the conclusion for taking cognizance under section 302. Where is the material to show that it is a homicidal death? Unless until death can be occurred on four circumstances. Maybe natural death, maybe homicidal death, maybe suicidal death, maybe accidental death. Where are the material before the court to satisfy that this is a case of homicidal death? If that is no material, the taking of cognizance under section 302 is not based on material record. The second aspect is to whom the process is to be issued. 202 inquiry and issuance of process on section 204. Unless and until the court is satisfied that there is at least material to show that the death is not accidental but it is a homicidal, question of 302 will not arise. So on these two aspects, if taken into consideration, the cognizance and process which has been done later on against the petitioners is not tenable in that.
File written note.
My lord, only to answer that.
You file written notes. I have spent 45 minutes. Yes.
Only I indicate that he was not initially he was not treated at nearest hospital. This was not treated at nearest hospital. That's it. The doctor Kishore Chandra Behera.
I understood it.
He was treated. He referred to Cuttack Hospital, and dying declaration was recorded in presence.
Don't go into factual aspect. The legal issue which Mr. Mahapatra has highlighted. You assist me there.
But there
don't go to factual.
But I'll argue on two issues. So far as legal
you have already argued. I can't.
No,
45 minutes.
Legal issue. So far as legal issue.
File written note.
But legal issue, but two aspects.
These are the cognizance says 45 minutes. I have heard. 45 minutes.
No, this is not a case.
I would have disposed of 3 epics by now. You file written note.
Only answer.
Whatever you want to say, file written note.
No, khali legal point
I understand this. His legal point, what he says is a relevant legal point. You assist me there. Give the judgment, assist me there.
Second criminal case for same occurrence is not maintainable.
That's what he says. That's what he says in other language.
Kishan Lal Chawla case that is reported in 2021.
Prepare a note and give me.
This is number one. Number two, that in a complaint case, while magistrate taking cognizance, some reason has to be assigned, not in a GR case.
I understand.
Some reason has to be assigned.
That's what he says. Unless you make out a case for homicide death, 302 can't be, because there is no reason there. That's what he has already said.
In taking cognizance order, order of taking.
I know that's what he said. In a cognizance order, unless you make out you have give reason saying that it is a homicidal death, 302 cognizance cannot be taken.
That my lord judgment.
Particularly when the GR case, cognizance has already been taken.
Yes.
Once you have taken cognizance, that's accidental death. In 202 and 20, you are taking cognizance 302, then you have to assign reasons, which is not there. That's what he is already
Your
said.
lordship is right. That is the crux of the matter to
That's
be
right.
argued with.
Now, don't go into factual aspect. Yes.
And only to answer that,
Okay.
and only to answer that question, my lord,
Yes.
whether the
You file
prosecution
written
can-
note. Yes, next item two.
and whether- and only, my lord, sort,
It's not such a big matter for
Well,
such a long
my-
hearing.
my only point that
You file written note, I'm giving you option. File written note, I'll read it, don't worry, I'll deal it.
Fine.
Yes. Okay.
Other two-
And judgments whichever you are citing, please highlight those. Otherwise, I have to read everything. That's the problem. Only those portion highlight. So easy.
ହଁ, ସେଟା ମୁଁ କରିଦେଇଛି ମୁଁ ଲେଖିଦେଇଛି
Please give. And if you want to add after the argument, if you want to add anything, you can add it.
ସେଇଟା ତ ମୁଁ judgment
Adjust
already
it.
କରିଦେଇଛି
Yes. Next.
So far as other two matters are concerned, so far as 205 rejection
The
205,
first matter is decided accordingly. We will.
it will be adjourned to some other times. Yes, only questioning the matter.
Yes.
May I please, your lordship? My lord, this is a petition for quashing of a FIR under section 482 of,
Entry mode.
under section 482 of CRPC.
Judgment is equal to entry mode. Yes.
May I please? My lord, this is a petition for quashing of the FIR under section 482 CRPC. The alleged offences are under section 498A, section 4 of TP Act, 294, 323, 506, 313, and 34. My lords, here the petition number 1 is the husband, and the rest petitioner are the in-laws of the informant.
Okay, I'll issue notice 498. It's 498 issue.
And 4,
Publish, my lord.
Item for your lordship, it has been infructuous as the DB miss case number 49 of 2021 has been set aside.
Oh. Public secretary, it might become influential. What is decided? In view of who?
It has been directed to both the parties to file their asset liability affidavits and also provide 15 days time to the appellant.
Matter was remanded back to the.
Yes, your lordship, it has been remanded back.
In view of the fact that the matter has already been remanded back to the trial.
May I take one?
Perfectly. Yes.
As the maintenance order was set aside, the wife and son will face difficulty. So I pray your lordship may direct on a trial court to.
You are the respondent.
Yes.
It is his petition, he says that it is infructuous. In his petition, you want relief. In an infructuous petition.
Yes, yes.
You have to file separate petition. It is his petition. He says that it is infructuous. And in his petition, you are seeking relief. Can't be. You have to resort to right remedy. Yes.
Blessed.
the 5.
Your Honor, in this case, the petitioner against whom cognizance, a process has been issued and cognizance has been taken.
Yes.
Under section 120B, 420, 467, 468, 471.
Yes.
Of IPC, your lordship. The petitioner, my lord, the facts about the case are like this. My lord,
Yes.
the informant, my lord, had a account in a bank. My lord, what has happened in that account? 11 lakhs rupees was kept. In a day, my lord, 9,60,000 rupees was fraudulently withdrawn by unknown accused persons. Thereafter, my lord, the informant lodged an FIR in the local police station, that is IIC Dharmasala police station. And when Dharmasala police station, my lord, did not take any action, the complainant filed a writ petition, and pursuant to the order of the passed in the writ petition, the matter was taken over by CBI. Thereafter, my lord, CBI ensued the investigation and laid charge sheet as against 3 persons. This petitioner, my lord, is an outsider and he has been charge sheeted along with the bank manager as well as a dealing assistant of the bank.
What is your name?
My lord, my name is, my lord, Jayaprakash Tripathi, my lord. In this case, your lordship may kindly see the order in taking cognizance itself reveals that absolutely there is no role played by me, and how the cognizance order has been passed, your lordship may kindly examine. The order in taking cognizance is at Annexure 1, your lordship, at page 13. My lord, if your lordship may I be permitted to read the order in taking cognizance, your lordship.
Yes.
My lord, this order was passed on 15/1/2019. My lord, the second para. The record reveals that on 13/1/2011, this case was registered against accused Jayaprakash Tripathi and some unknown bank officials of the UCO Bank, Jarka, Dharmasala, on the direction of the Honorable High Court, Kotak, by the order number 7 dated 21/12/2010 of the Honorable High Court, passed in WP serial number 484 of 2010, filed by Ramachandra Nayak, and investigation was conducted. My lord, page 14. Initially, Ramachandra Nayak had filed a case.
Come to page 32.
13.
32, 32, last paragraph.
Yes. Your lordship.
Last paragraph.
Investigation revealed, your lordship. Investigation revealed that on 14/5/2009, for the first time, a checkbook containing 20 leaves was issued to the account holder. The said checkbook was received by one Jayaprakash Tripathi, and named accused of the affair and friend of account holder, on behalf of the account holder. No requisition to issue the said checkbook was found to be available in the bank. However, my account holder stated that he had given a requisition at the bank for issuance of the checkbook. It is pertinent to mention that at the relevant time, Sri Pratap Chandra Maharana was the manager and issued the said checkbook to Sri Ramachandra Nayak through Sri Jayaprakash Tripathi. The above circumstances indicates that in order to cover up the issuance of subsequent checkbook without any requisition, Sri Pratap Chandra Maharana, manager, have removed the said requisition from the bank. During investigation, it is found that during the period from 14/5/2009 to 11/1/2010, the account holder Sri Ramachandra Nayak had used 19 bureau checks and genuinely withdrawn the amounts. On 11/1/2010, only one check was remained to be used. Investigation disclosed that on 13/1/2010, Pratap Chandra Maharana, manager of UCO Bank, Dharmasala branch.
Yes, Mr. You are appealing.
Oh, yes, your lordships.
Yes. Against this Tripathi, what is his name?
What is the
name?
Jayaprakash Tripathi.
Jayaprakash Tripathi. What is the allegation? He has only received the checkbook. Purportedly, there was a requisition. That requisition is concealed by the bank manager. What is his role?
Your lordships, I require 4 weeks time to file a reply in the matter.
You want to file reply, but there is nothing against him.
Your lordship, there is a process. I'll just seek some instructions and file a reply so that the matter may be taken up. Your lordship.
Let him file reply. It's a 9/6 adjournment to file a reply to the.
May I pray that the interim order may be passed for a step further proceeding?
No,
because in the connected case that order has been passed.
What did he say?
No, it's in the connected case I am appearing. Interim orders are there where stay has been granted.
Yes.
Same order.
3 weeks. Yes.
Interim orders to continue in my matter.
Yes.
6.
Your lordship may fix a date so that your lordship, because this matter, because your lordship is the connected matter, it was listed last of 2019. And it is listed after 5 years, your lordships.
No, because it was last listed on 12/2025.
This side of the vacation, you give a date, specific date.
Okay, your lordships.
Because stage operating, yes.
Madam, item 6, your lordship. Madam, I filed a requesting for the proceeding, your lordship. The POCSO case, madam.
You can notice good. I'm issuing notice, let us see. Notice has already been issued. Okay.
And 164 statement is clearly stated in the.
At present,
As a notice was issued already, yes.
Well, my humble submission is that, well, at present, in date of occurrence, well, 2013 errors. 2013.
Have you seen 150?
Yes, errors.
Left?
2013. And at present.
He had gone to attend the call of nature.
No,
You
no.
went from the back, put the rumal in his mouth,
My simple prayer.
lifted her and take it to the house and rape.
Madam, at present, both the family members settled their matter, madam.
No. Completely.
And the victim is already married,
I
madam.
have the notice was issued to the state council, opposite party. Mr. Jena produced the case diary, and I perused the statement of the victim recorded under 164 CRPC. She has in her statement has very categorically
Madam, a simple permitted to withdraw your words.
present listener in view of nature of allegation and the allegation statement of the victim under 164 CRPC. I'm not inclined to entertain.
Madam, may I pray one thing?
At this stage, yes.
Permitted to withdraw your words.
Withdraw. Argued sometime and yes.
Apply yours.
7 year lordship, may I please my lord. Last occasion, lordship issue notice and stay the NBW order. And as per the instruction of this petitioner, petitioner is surrendered before 15/4/2025.
What do you want?
2 weeks time may be surrender, your lords.
Further 2 weeks time.
Right.
For the reason stated in the application, we time for surrender to extended.
Other request person.
5/5, huh? 5/5.
5/5/2025.
Make clear that no further extensions shall be granted in any circumstances, huh? On any ground. There are 3 responses.
Lordship pending is there. Case is pending.
No, I have already disposed.
My lord, issue notice and case is pending there. Today.
No. Why? This matter was already disposed of.
No, my lord, this case is pending. Lead this matter 17/4/2025. Other
I have stayed the NBW.
My lord.
And asked you to surrender.
But the case is pending.
Sorry?
But the case is pending in the last occasion order.
I'm not able to follow what I. But he asked for, he is asking for extension of time for surrendering.
No, my lord, it is not an extension time, but 15/4/2025 is the last date for surrender. Your lordship has direction to surrender before the court below. And put up this matter 7, para 7. And put up this.
That's what I'm extending. That's all. Yes.
Item 8.
Well, item number 8, I need 2 weeks after.
Good.
Item number 8, can I 2 weeks after?
The request. Stay with the July.
Item 9.
My lord, I am in VC. My lord, petitioner of CRLMC number 1219 of 24 and CRLMC number 2161 of 24 are willing to compromise the case with petitioner of CRLMC 326 of 2025, my lord. All the offences are compoundable. My humble submission, your lordship may direct JMFC COC2 to compromise this case within a stipulated time period, my lord.
My lord, appearing from 2141 CLMC number.
There are how many? 3, 1, 2, 3, 4 matters.
My lord, 2141 of 24 wrongly tagged, my lord.
2141.
My lord.
2141 तो डिटेक्ट कर दिया 2141 डिटेक्ट कर दिया and what about the other three cases?
Well, it's a case and counter case. Well, in the first case, for Annapurna and Devasis Patri, they are mother and son. Annapurna Ballad is criminal miscase number 1219 and Devasis Patri is 2161 of 2024. They are the mother and son.
All are compounding offenses.
294 is not compound. 294
Which is compounding?
is.
Is that the case? Then file 320 and finish it up.
Well, it's better to, if my lord will send it to the mediation center, there they can settle because my friend's client is an Amin. He was unauthorizedly measuring my land. I opposed.
Then what I'll say is the parties have settled the dispute and they want to work out the
No,
terms.
my lord, sir, with regards to settling of dispute, that I have no instruction.
That's what he says.
No, I don't. Well,
What-
let it be taken
Yes.
up. Let it be taken
Yes,
up.
Mr.
one week
Mantu, what do you
after.
want to say?
I have no instruction in
My
that.
lord, both parties are willing to compromise the case. They
So bring them.
inti-
Bring them here. I'll pass the order.
My lord,
What do you want to bring?
my lord, this case may be settled in JMFC COP to Puri, my lord. That will be okay within a stipulated time period. If they are not,
No, well, it may be taken up on 24 or 30th pilot, which will be convenient for you, pilot.
No, but I think I'll send it to mediation. That's the better idea.
Yes, better.
That's the better idea.
So let it be settled there. If they are really interested.
Where is it pending?
It is pending, my lord. Puri.
Puri.
Uh,
Puri District Court.
Puri. Better.
my lord, JMFC COP to Puri.
What JMFC COP to Puri? Medicine settlement is JMFC COP.
Right.
What?
Regarding to the nature of the litigation and the fact that the counsel for the you are appearing for whom?
He is appearing for my lord Jivan Jyoti
Jivan Jyoti Mahanti, my lord. The petitioner.
The learned counsel for the petitioner submits that the parties have arrived at our they're settling the dispute. They're attempting to settle the dispute out of court, and then it government that agreement took place on the party terms of settlement. Mr. Deputy Governor, Senior Counsel appearing for you are appearing for?
I'm my lord in criminal discuss number 1219 and 2161.
And 1219
and 2161.
One appealing for the petitioner submits that he has, although he has no instruction regarding the term regarding the settlement, however he submits that in keeping in view the nature of allegation, there is no harm attempting for a settlement, attempting for settlement. With regard being had to the statement made by
He realized that he has committed a mistake and I have already lost that information.
So
So
that
the counter must see he has come with the case.
and by the counsel at the bar. I feel it appropriate to send that matter to the Puri District Court Mediation Center. And the parties are directed to appear before the mediation center on the 22nd April at 4:30.
Well, it's still 22nd.
No, they'll appear before mediation center 4:30, and the coordinators will further pick the date for the purpose of exploring the possibility of settlement. File the report before the court by next date appearing, read the matter on 30th.
Because the order will not by that time it may not be there.
Communicate.
So
24th, and then lease it on 5th. Lease it on 5th.
Entry model.
From 10.
May I please? Last case was filed an affidavit requesting the
initial assessment of the information. If I have filed additional affidavit, lordship.
Yes, what is that?
Additional affidavit will file in court or 2000.
There is no additional evidence.
Copy between online.
Do you have the copy? It's not there.
System, copy is the.
Have you filed in the counter?
No.
Huh?
It's online file.
It's not included. When counsel for the petitioner submits that he pertains to the order dated 48/3/2026, has already filed the documents. However, the same has not yet been brought on record. The registry directly to locate the case and place it on record. Please the matter. Yes.
It's a urgent matter.
We'll give it.
So it is a 23rd.
You should have ensured that it should be there on record. Yes.
Capital.
Not 23rd. Yes, next.
Capital.
Sir, it has to come on record. How can I,
Maybe.
These are paperless code. Where will I keep that?
For I have filed.
You should have ensured that it, therefore I am directing the registry to locate it and place it.
25 minutes I paid.
Not 21st, not possible.
Yes. 25 is the date fixing for.
You should have done it. Yes.
May I please, Lordship? My Lord, I am on behalf of Suryakant Dwivedi. It is a case of the questioning of the entire criminal proceeding, my Lord. Issuer settled between both the parties. Kindly fix a date for the appearance of the part.
What are the offences?
Offences are 294, 323, 493, 4506 of IPC, my Lord.
I don't know. I'd simply adjourn the case. Adjourn the case. Yes.
Any date?
We'll give it. Yes.
I'm challenging the cognizance matter. One of the offenses is SC and FT minor. My response is this is not within the public review minor. I have annexed the 161 statement minor.
What are you challenging?
The cognizance order minor.
Yes.
Last time minor was pleased to direct for filing of the 161 statement.
Yes.
I have filed mine. The statement of informant is Sushant Behra Mara.
You are Sushant Behra? No.
Informant is Sushant Behra Mara.
Informant. You are Rajendra Prasad, Ramesh Tapati and Tara. Yes.
May I read the statement, my lord?
Yes.
23/1/2022 ତାରିଖ ଦିନ 11:30 ସମୟରେ ଆମ ଗ୍ରାମ ରାଜେନ୍ଦ୍ର ଶତପଥୀ ତାର ସାଙ୍ଗ ମୁଲଡା ଗ୍ରାମର ପୂର୍ଣ୍ଣା ମହାନ୍ତି ମତେ ଗୁଡିବନ୍ଧ ନିକଟ ପାର୍କ ପାଖକୁ 2,50,000 ଟଙ୍କା ନେଇ ପ୍ରାର୍ଥୀପତ୍ର ଉଡ୍ଡ କରିବା ପାଇଁ କରିଥିଲେ। ମୁଁ ଏଥିରେ ରାଜି ନ ହେବାରୁ ମତେ କେଉଟ ପିଲା ନିର୍ଯାତି କହି ସୋଲା କହି ମତେ ଉଭୟ ମତେ ସର୍ଟ କଲା ଧରି ଘୋଷଣା ଟଣା କରିଥିଲେ। ଏହି ସମୟରେ ସନ୍ତୋଷ କୁମାର ବେହେରା ରାଜୁ ବେହେରା କେମ୍ ଆଫ୍ଟର ଦ୍ୟାଟ୍ ମାଇ ଲର୍ଡ। I am reading the statement of Santosh Behra, Raju Behra, my lord. May I, my lord? That is statement of
Pura.
Yes. ମୁଁ ସେଦିନ ରାତି ପୁରୁଷୋତ୍ତମପୁରରେ ସରି ଘଟଣାସ୍ଥଳ ଯାଇଥିଲେ ସେଇଦିନ ରାତିରେ ମୁଁ
ତାଙ୍କର ଭାଇ ଆମ ଦ୍ୱାର ନିକଟକୁ ଆସି ମତେ ମୋର ଜାତି କଥା ଉଠାଇ ଗାଳି
ଦେଇଥିଲେ। Within that in a compound place, but not in the public view. My submission is
in the village. You went to their house in front of the house.
But nobody is stating same matter. He is stating about two witnesses.
Cognizance. Why should I go into all these things?
Let it be.
You have to cross-examine him, asking that who has heard it. While
the informant is
all
stating
about has to be elucidated from the witnesses during the trial.
But the informant is
I can't presume that nobody was there. How can I presume?
My lord,
have you taken photograph? Please.
The informant is taking about two names, my lord. I am reading the statement, two witnesses, my lord. Santosh
Behra
and
say that all of you went to his house.
Yes.
ଘର ସାମ୍ନାରେ ଆସିକି ଗାଳି ଦେଲେ। That was a village. Anybody was present there or not present there? How will I know?
He is not stating so, my lord. The informant is stating not so.
ଘର ସାମ୍ନାରେ ଯାଇକି ଗାଳି ଦେଲ
ଆଜ୍ଞା
ଘର ଭିତରେ ପଶିକି ତ ଗାଳି ଦେଇନ ଘର
ଘର
ଭିତରେ
ସା-
ପଶିକି ରୁମ ଭିତରେ ଗାଳି ଦେଲେ ଲେଖା ହେଇଛି କୋଉଠି
ଘର ସାମ୍ନା in the night, my lord.
ନାଇଟ୍ ବି ଥିବେ ନାଇଟ୍ ରେ ହାଉ ଡୁ ୟୁ ନୋ
But she is not stating
that
so.
those things you have to ask the witness when he comes to the witness box. When he comes to the witness box, you have to ask these questions to create a doubt.
Let it be to another, I will satisfy.
No. You withdraw it and file
And the judgments with
If
me,
you want
my
to file the, application for discharge, what judgment in fact?
The cognizance has been passed, my lord. And our honorable High Court judgment there, my lord. I may found my lord judgment.
I'm completely disagreeing with the judgment. Whichever you say.
Let me take a
On
one
fact.
pass, man. One
No.
pass.
You withdraw it and file. Unnecessary, these cases are pending. Rather, you file a discharge petition. Try there. I'll give you that opportunity to you. File a discharge application.
So more koya kata je khondiya
Discharge. See, the court which is going to frame the charge, he may go into all these things, but not in the cognizance thing.
So more koya kata je my lord, I may submit.
Seek to withdraw the petition to move a specific application for the trial court seeking discharge on the grounds as has been urged in this petition and other available grounds. We may liberty granted to the petitioner to move appropriate application if such application is the trial court the trial court shall deal with the application in accordance with the law on the basis of the material placed by the investigating agency in the charge sheet and the document form for documents. Move application, that's the better idea, you argue. Yes.
ଖଣ୍ଡିଆଟା ଯେତେବେଳେ ଖଣ୍ଡିଆଟା ଯଦି କ୍ୟୁଆର କରିଦେଲେ ହବ କ୍ୟାନସର ହେବା ପୂର୍ବରୁ ଇଟ୍ ୱିଲ୍ ବି ବର୍ତ୍ତମାନ ସାରିଦେଲେ କାମ ସରିବ କନଭିକ୍ସନ ହବ ପୁଣି ଅପିଲ ଆସିବ
Conviction, you file a application. I have given that to it. Yes.
Apply.
Yes.
30.
Ask for some status report of this one. Very funny, the wife.
Got it.
They did not receive. But actually, the present petitioner is the wife of Lingaraj Mohanty, who was one of the associates.
That you say.
No. The direction was to obtain status report. Have you got it?
No.
No, then it has to be urgent. But why half-heartedly arguing? If you want to go ahead, I can go ahead.
That is what I.
Because there is a specific direction. Obtain status report vis-a-vis the role attributed to the present petitioner. Get the status report.
The police can entangle anybody for any purpose.
Pursuant to the order dated 19/2/2025, the State Council has not received the instruction from the investigating officer. Therefore, he seeks an adjournment. Leave the matter the second or third March, May.
Second, my lord, I'm in accommodation. Second.
Yes, then
Next week.
Six.
14.
May I please, Your Lordship? It is that case where a company has been victimized because of the high-handed action of the ED people, my lord. ED, who is a premier investigating agency, is no way connected. My lord, my land friend, I have also gone through the entire affidavit. A bulky affidavit has been filed without answering the query Your Lordship specifically raised. What is the basis or what is the reason to believe why I have been implicated in this thing? Merely because my father-in-law is owner of two companies and has some business link with the principal accused. I have been implicated in this. Your Lordship kindly see para 2. First allegation is when there is alternative remedies available. So this proceeding is not maintained. Para 7.
Well, how you are linking this company?
Lordship kindly see paragraph 7 below. Purpose of the here after reaching of the accounts and seizure of the vehicle under section 870 and OA has been filed before the adjudication. So he can go there and place all these questions.
Why unnecessary harassing people? If there is nothing, I'll quash it. 482 proceeding. You
I am not
tell me
notice,
whether
sir.
anything is first you implicate someone, thereafter you justify. or you, the justifiable reason is there, you do it. That's very, you have implicated someone. Now you are trying to justify it. Looks like, I don't know. Maybe you are correct. Let us see. If there is nothing, I'll pause it, finish it. Yes. You know, you are half-heartedly arguing. You also know.
I have come
I know.
across relevant order.
Let us see. Yes.
The Chandrasekhar Samar, proprietor of Messrs. C Constructions, represented the company Messrs. C Monolithics Private Limited, this present petitioner. And Messrs. C Express Transport Private Limited, being the director of the said two company. He is a close member of Series Akhilakant Rao, who is the principal acting.
Absolutely.
Since the year 2004-2005. Approximate, turn to the next page, paragraph C. Further, during recording of the statement under section DMLA 2006, Chandrasekhar Samar has been one of the directors since 15/7/2010 of Messrs. Sri Monolithics Private Limited. And the company was formed in the year 2010 for doing business in the mineral so and so, so and so. Then your worship may speak over the paragraph E. That's it. Chandrasekhar Samar in his voluntary statement under section 50 of PMLA 2002 inter stated that the C BMW X1 vehicle bearing registration number so and so, cost around so and so, out of which so and so was financed from BMW Finance, and the remaining required was sourced from the bank account of Messrs. Sri Monolithics Private Limited. Therefore, the down payment as well as the repayment of vehicle loan is sourced from the bank accounts of Sri Monolithics Private Limited, wherein high value transactions with Sri Ratikant Rao and the company under his directorship took place. Merely levying the said amount as loan do not free them from the studio. That ill-gotten money proceeds of crime generated by Sri Ratikant Rao and his associate after the commission of civil offence are grounded, using the banking channels in his money laundering activities, the business entity associated with Sri Ratikant Rao and the accomplice play an instrumental part in the protection of proceeds of crime, and therefore the extent of association of Messrs. Sri Monolithics Private Limited with Sri Ratikant and person entity associated is under investigation. That OA number 46 2005, the retention of the properties seized frozen during the course of such conducted in so and so has been filed on the basis of reason to believe that such seized and frozen properties are proceeds of crime. And if not seized frozen immediately, there are sufficient chances that the same will be transferred or otherwise dealt with, which would result in frustrating the proceedings relating to investigation, adjudication and confiscation under PMLA 2002. The said reasons to believe are backed by material facts, bank records, transactional trace, and other corroborating evidence. The respondent directed and sufficient material and document establishing private case that the seized vehicle in the vehicle involved in money laundering as defined under the sector.
Then the only link is the bank account which you are saying at E.
Yes.
That Chandrasekhar Samal, my lord, he is no way connected to our company, my lord. Chandrasekhar Samal is my father-in-law, who is one of the directors. There are two directors, the daughter of the Chandrasekhar Samal and her husband. These company was established in the year 2010, and both the accounts.
Chandrasekhar Samalo and Ratikant has a
director. Might be, my lord, might be. I am no way connected with him. I am no way. So far as the company is an accused, I am for the company is a jurisdiction person, my lord. I am representing company as a director of that company. Can they make such allegations by saying
enemy's friend is enemy?
No, that's true. But they have not shown a single transaction which shows that these ill-got money.
I don't think you have any link with the company as such.
He himself, that Chandrasekhar Samal himself.
Chandrasekhar Samal is not a director.
Yes, he is not a director.
Then you have established Chandrasekhar Samal and Ratikant, I can understand. Anything linked to Chandrasekhar Samal, you can do it. But this company, Chandrasekhar Samal's daughter, is one of the directors.
Yes.
Merely because daughter in the entire family, everybody is, can't do that.
These property are outcome are generated as a loan account, sir. Both are, and
And
during March they have
valid,
seized.
you yourself have said that loan was availed for the purchase of a BMW. Then
Other account also, that is your loan account.
Whatever they have, that's why this affidavit was like, they prepared the affidavit, they sent it, I just entered.
Your lordship can
you have
your lordship can
implicated him thereafter trying to justify, bringing this, that.
One criminal division, your lordship delivered a latest judgment dealing with that Sundarabhai Ambala and the three parties case. Retaining this money by the prosecution will not be helpful for either of them. Very well discussed judgment your lordship delivered while releasing a CBI investigation.
This is guideline I have formulated the guideline.
Yes, yes, my lord, your lordship right. I am much obliged. I got it yesterday.
I'll pass you.
Much.
I'll try to do it today, sir. Once it is reserved, it is a big burden.
But I appear for the bank. I am for the bank, my lord.
So that stay something. Has he been arrested? No.
Not arrested, but police is still sitting at its place, my lord.
I told Mr. Jana not to.
I was informed yesterday night, my lord, that police was supposed to come back yesterday. But I think after getting instruction from my friend, they said, no, we will not go, we will wait. Because they have also independent matter is likely to be taken up today. They have stayed back, my lord.
And Monday.
Or you also can call it Monday.
Monday.
But I am for the OP4, my lord, in that matter. For the bank.
You are for bank, huh?
Yes.
Opinion first bank.
Obliged. Is there? What is it now? Next. Ramchandra.
16.
16.
16. The informant is the Serum Finance. Already dispute settled. Already allegation 1.13 lakh amount loan amount. Out of that 69 lakh 54,401 already deposited. Settle ହେଇଯିବ ଖାଲି notice ଟେ ଗଲେ ହେରି ଆଉ ପଇସା I'm ready to pay all.
Part of the money alleged fraud. This is the fraud case.
My lord?
420.
420, 490, 460.
Part of the alleged fraudulent amount has already been paid. There is a scope of out of court settlement. You can notice to opposite party written amount. Yes.
17.
My lord, ଆଏଟା ସେ time petition ଟା ଟିକେ allow କରିବାକୁ.
Statement made by the petitioner. It is open for the petitioner to move up to the court trial for further. Yes.
17.
Obliged, my lord.
Made. Challenging the provisions order. Actually, I have not challenged the provisions order, but difficulty is, my lord, the present petitioner was involved in the case under section 296, 115, 2, 74, 76, 351 and 2. After lodging of the FIR, my lord, the present petitioner was released under section 35(4), my lord. 35(4) notice was issued by the IO, and I was appeared, and I was released. After getting the summon, my lord, your lordship can have glance to page 21.
21, yes.
5/11, 12/24. Your lordship taken, my lord, that offence cognizance is taken. There is sufficient ground to proceed against the above named accused person in case the accused person have been under section 35 of the BNSS. CS is directed to hand over the case to the dealing clause. Office is directed to prepare the issue summons. After I have appeared before the, after getting the summon, I appear before the court below. But the court below opened that since one of the offence is trial by sessions, so I have no power to release him.
Where is that order?
For that reason, my lord, I have withdraw that case. Here, let's page 22.
Yes.
76 of the BNSS, my lord. It is, my lord,
So what do you want now?
My lord, my difficulty is, my lord, once a person released on 35-4, my lord, bound, he must have to be released on bail, my lord.
So that Agrawal. Sushil Agrawal.
Still, the higher offense case, the higher offense mother 9. At the 35-4, I have already released. Higher offense is and say, they know, and say, go to Jehetu 76, my lord, Court of Sessions. So, more power name.
But you are challenging the cognizance.
Cognizance, এটা তো withdraw করেছি আর কোনটা আমি সেই that is my lord সেইটা the only
I'll direct the SDGM to decide your application on the basis of Sushila.
35-4 রে once, my lord.
I'll record that out.
সেটা সেই observation হয়ে গেলে my
the petitioner is agreed by the order dated 5/11/2024, whereby the cognizance of offences punishable under section 295, 74, 76, 115, bracket 2, only 351, bracket 2 of BNS has been taken against the petitioner. Has been taken against the petitioner, and process was issued to him. And then counsel, Mr. Tripathi, can counsel for the petition submit that the petitioners were issued notice under section 35, bracket 3 of BNSS, that is 41C.
41.
Bracket 41C of from. Although he has failed the order dated 5/11/2024, whereby cognizance of offences have been taken. However, he submits that he is not pressed his application. Rather reserves the right to educate all the issues before the court below at appropriate stage. But at the same time, Mr. Tripathi submits that on 6/3/2025, pursuant to the summoning order, when he appeared before the court and moved application, the petitioner appeared before the court and moved application before the trial court for grant of bail. The trial court, the SDGM Pulwani was of the view that one of the offenses, which offenses?
76. 6 of the BNS.
One of the offenses, namely 76 BNS, being tried by the magistrate, trial by the sessions, the magistrate cannot grant bail. In that, confronted with that situation, he had to withdraw the application. Mr. Tripathi submits that since the petitioner was already under notice under section 35(3) for 35(3) or 35(3) of PNS, the SDGM ought to have released him on bail. However, since the SDGM declined to do so, and he was forced to withdraw the application. In these circumstances, he submits that liberty may be granted to the petitioner to move a fresh application for grant of regular bail before the court of SDGM Pulwani. On all the grounds that has been raised before this court. Liberty granted to the petitioner to move bail application before the court of SDGM Pulwani. If such application is known, the same can be considered, keeping in view the judgment. Keeping in view the fact that the petitioner was under notice under 35(3) BNS. And in the light of the judgment in Sushila Agrawal and so on and so forth. Two-three judgment Agrawal and consistent with this liberty, the petition is issued. You move now. You detail.
My was up.
18.
Lordship, I am appearing to virtual mode. Lordship, I pray for a Passover. This matter may kindly be taken up after lunch.
Passover, I just done.
As per the instruction, he has been killed by the informed party. That matter already been infructuous. He has been
Infect
killed.
case, okay. Infect.
20.
My lord, the petitioner challenging the order passed by the court below for not granting the NOC for issuance of passport. My lord, the fact of the matter is that the state medicinal plant board, in order to promote the cultivation of medicinal plant, disbursed some amount, subsidy amount to the account of some farmers. And what the allegations is that the said amount was not disbursed to the loan amount, rather it is to the savings of accounts of the farmers. And in that,
You are agreed by which order?
The input order is 23/11/2023 and placed in page 31 annex 7 A.
Yes, madam.
That order was passed by the Gramnya Lordship, wherein the application for grant of passport authority to direction for passport authority to grant passport has been rejected.
Renewal passport or grant?
Yes, my lord, my lord, it is since 14 years. In the order itself, the learned judge has mentioned the charges against the accused person has not yet been filed, and the case is yet to be completed. My lord, 14 years since then, nothing has been happened yet. So the petitioner is now 66-year-old, and he's asking for the permission.
Are you holding a passport or not?
No, my lord. This one, so I have applied for
First time you applied.
Previously applied, rejected. Then again applied, again rejected. For that,
where is the rejection?
Next 6 your petition also can against grant of passport. That is
yes, my lord.
Petition for grant of permission for grant of passport.
Grant of passport, it's all right. Where is the rejection?
That
Where
is
is the rejection?
31 page, relevant page 32. You will also there in the next page.
The passport authority rejected.
Yes, my lord.
Where is that?
Annexure 5, my lord. Page number 27. Objection with the reference to passport application also. In that, they stated that if there is any criminal proceeding against you, you just go to the concerned court and ask for the NOC. And so that the petitioner went to there and
Yes.
asked.
Against that order, my learned
He
friend
is
can
facing-
directly up.
He is facing trial, doesn't mean that he doesn't have the right to hold a passport also.
Yes, that I am not disputing.
What is this? Why should unnecessary?
Against that order also under annexure 5, the petitioner can directly approach this honorable court under section 226 and 227. But without doing so, file the petition with the Law and Trial Court. Law and Trial Court is in his order clearly mentioned. Also, can you glance your page 31?
Just forget it.
Yes, your Lordship. Your Lordship can.
Petition is agreed by the order dated 23/11/2023, whereby his application for grant of no objection for applying the passport has been rejected. That accounts for the petitioner taking me to annexure 5. Submits that the regional passport authority has rejected its application grant of passport by its order dated by this letter dated 14/6/2023 inter alia stating that yes 27 page 27 paragraph police submitted an adverse report adverse police verification report. Adverse police verification report so and confirms also you have the supporting document from tribunal case and why you submitted the report. ठीक है ये दूसरा पैराग्राफ लिखो तीसरा पैराग्राफ दूसरा पैराग्राफ since the passport authority has after receiving the letter dated 14/6/2023, the petitioner moved the application before the Gram Nyalaya Tabari inter alia break for praying for no objection. Praying, inter alia praying agent for page 30. 30. The application was heard and the Ramnale, Otabira, in CMC number 17/2023, turned down the applicant, turned down the petition. Getting a passport by a for the country right, right. Therefore, pendency of not the bar for holding a passport. Holding a passport. Mayor holding a passport is not necessarily to ensure that he will be traveling alone. For the purpose of abroad, after obtaining the passport, the petitioner for that matter has to move application before the court below settlement condition will be conducted. And the petitioner is only asking for no application for the purpose of holding a passport. Since there is no legal impediment granting the passport or the empty notice. In fact, the trial court is directed to pass the orders on the matter. The petitioner is at liberty to move the submission of the trial court, reiterating where the such application will be moved. The necessary order will be passed by the court with this observation. Yes.
21.
Yes.
Case of 2015 matters. Chassis committed and is issued matter. The author has surrendered, petitioner is not surrendered, declared as
Sorry?
Petitioner is declared as executioner matters. That is the end point. Matter the kind of
2015, this business showing that after has been filed.
Yes. You go and appear. Go to the cognizance is taken on that day.
And by the context,
the petitioner is one of the accused in the fire number Delgana, Tumusinga PS, case number 26 of 2020. After investigation, charge sheet was filed. The single case on 6/7/2050, showing the petitioner as an absconder. The trial court, by the order dated 23/12/2050, has taken cognizance of offences, Constitution 294, 323, 506, and 44 IPC, and also issued MBW against the petitioner, as the petitioner has been absconded. Petition is agreed by the state order and has filed. Insofar as the cognizance, taking of cognizance, insofar as the order pertaining to the cognizance, taking of cognizance is concerned, I'm not inclined to this petition at this. However, insofar as the issues of eligibility by order dated 23/12/2015 is concerned, the petitioner is granted liberty to appear before the court on or before 10th of April, 10th of May, and resort to the remedy. Till then, the execution of NBW issued by the SDJM Kamakhya by the order dated 23/12/2015 shall remain subject to petitioner depositing 1,000 rupees, 1,000 rupees for the cost. Local bar, Kamakhya, there is a Kamakhya bar. Yes.
22.
May I please, Your Lordship. Challenging the mile of criminal proceeding, Your Lordship, kindly see the page 13. That only allegation he has given the fist blow on the face. How my Lord 307 is added? Your Lordship, kindly see the page 23. 23.
Yeah.
The requisition of the police that the assaulted The given the feast,
Executed by S. Tripathi.
yes, he's a constable, my lord, and it is there is a court injury. Feast that is
Read it, but I can't read it.
that on 14/11 ये attainment में they have noted accused persons who is in duty right and assaulted Tripathi and his father village by means of fist, kick blows, causing where is my court injury, that is next page. The court injury that is the bottom
Bleeding injury.
no court injury like है सब
No, bleeding. Just
bleeding, only bleeding. हाथेरे जो मारी हो where is on his face.
Face, what is
Yes.
said?
That you'll also kindly see next page. There is court injury as you could where 307 asile केंद्र. What is 307?
Why not?
No, as you
You
can
have to see the intention.
no. कोटे आसिला हटारे गणोरे थेहिची कोटे that
You have to see the intention.
No, intention there is
doesn't mean that you have to have grievous.
No, he has no intention to ये. The कोटे spur of the
You
moment.
have asked the accused whether you have you asked the accused whether you have intention.
No, that is also there is a 307
coming at this stage.
this is 307 is not met out.
Not made out, then go and argue that charge.
That is
You argued the charge. Cognizance is rightly taken.
cognizance part में आसे नहीं पर that 307
Charge sheet, your lordship, page
It is
21.
filed, yes, I know. That cognizance.
He has given a kick blow to the.
Yes, there are other injuries.
Yes,
sir, not-
only
There are other injuries.
जो मुंह को जो मारला कोटे
Bleeding injury is there and other injuries are
only
there.
allegation, that only allegation.
You have read the medical report.
अच्छा से
Reading medical report.
से उड़ा पूछ
Then
नहीं किसी
bleeding injury is there.
नहीं मुन्ना
and other
नहीं
injuries
on
there.
offense ना हो
How have you?
नहीं other offense में मु ये कुछ तो 307
You had taken charge.
no notice जाओ
No.
yeah
Petitioner is saying the in this petition.
lordship to give some order order date करो आओ उठे दिन आसु
No.
मु I'll cite some
No,
judgments
this court is completely burdened because of this.
after vacation आसु मु
No.
I'll cite some judgment.
No, either withdraw or I'll pass the order. Withdraw it, file it right. Cognizance is also not taken. Only charge sheet is filed.
Yes.
You don't know whether cognizance will be taken or not. You argue that.
Permit to file the better application.
You do that. That's a better idea. Right? Why are you rushing to the court?
No, because when the 307
you will invite some observation. Unnecessary. That will prejudice you.
My lord, the 307
Still the
no, admittedly the 307 is not better.
cognizance is taken. Only charge sheet is filed.
Yes.
You know what kind of charge sheet. They entire IPC they write.
No, there is police over here.
Wait.
The exaggerated allegation has been given.
Wait till the right time. Otherwise, at the very threshold, if you come to the court, you invite some observation. That will unnecessarily create problem for you.
Permit to file the
And it
better.
will be easier for the trial court to, frame the charge and all. Why are you unnecessarily?
Permit to file the better application.
Better. Yes, let it call for the petitioner. Please withdraw this petition to file a better petition at the appropriate stage. If cause of action arose. If cause of action arose, then only. If
Yes.
307 cognizance is not taken, why will you file?
But
Wait.
Yes.
Yes.
23.
Credit come along with 1449 by 25 minute. Yesterday was in list matter.
Sorry?
Yesterday was directed to list on list with 1449 by 25.
Notice ହେଇଥିଲା ଗଲା.
Issue notice. Settle notice is.
Yes.
Notice not necessary, my lord. Compromise is both party will come, my lord, and thereafter the case will close. Notice not necessary, my lord.
Bring them
Yes, sir. Yes.
whenever it is. Yes.
24.
Kindly pass over.
25.
26.
Here the case arises out of a protest petition. FIR was lodged. After investigation, police filed the final report. That case is false. Case counter
What are
case.
the offenses?
Some magistrate tribunal.
354.
354 ଆଜ୍ଞା ଦିଟାକ ସେମାନେ ପୁଣି ପ୍ରେଜେଣ୍ଟ ନଥିଲେ ବୋଲି 164 ଆସିଛି 161 ଆସିଛି ମୁଁ ଖାଲି ଆଜ୍ଞା କହୁଛି ଯେ କେସ୍ କାଉଣ୍ଟର କେସ୍ ସେମାନେ ଟିକେ ଟିକେ ଆମେ ଆଜ୍ଞା କହୁଛି କେସ୍ କାଉଣ୍ଟର କେସ୍ ତାଙ୍କର ଆଜ୍ଞା ସରକାରୀ ଚାକିରି ଆମର ବି ସରକାରୀ ଚାକିରି ତେଣୁ ଏଇଟାରେ ନୋଟିସ୍ ହେଲେ ସେମାନେ ବି ଆସିବେ ସେ ଏକାଠି ସରିଯିବ।
That's what I'm saying. I'm issuing notice. I understand. I just see 354 small offenses.
354 ନାହିଁ ଆଜ୍ଞା ପୋଲିସ ଫାଇନାଲ ରିପୋର୍ଟ କାହିଁ ଗଲା?
But now protest petition is filed.
ହିନ୍ଦୀରେ ମତେ ଆସେନି କହିବାକୁ ବୋଲି ସେ ମତେ ଚଲେଇଛି ହିନ୍ଦୀରେ କୁହନ୍ତୁ ସେ ମୋର ସାଙ୍ଗ।
Okay. Issue notice to move application before trial.
ଆଜ୍ଞା
Move application before trial court file.
ଷ୍ଟେ ଦେଇ ଦିଅନ୍ତୁ କାରଣ ସରିଯିବ ଆଜ୍ଞା।
Stay ଦେଲା ପରେ ଆପଣ ବି ଆସିବେନି ନା?
ନା ନା ଡେଟ୍ ଟା ଫିକ୍ସ ହବ ନା। ମୁଁ ଆପଣ ଦେଖୁଛନ୍ତି କୌଣସି କେସ୍ ରେ ମୁଁ ଆବସେଣ୍ଟ ଅଛି।
You move application for adjournment. You bring here, I'll quash it. Monday you bring here, I'll quash it.
ଷ୍ଟେ ଟା ଦିଅନ୍ତୁ।
I am interested.
କାହିଁକି କହୁଛି?
I am interested in closing of the matter.
ନା ନା ମୁଁ ଜାଣିଛି ଆଜ୍ଞା। ମୁଁ କାହିଁକି କହୁଛି କି ଷ୍ଟେ ଟା ଦେଇଦେଲେ ସେମାନେ ତାଙ୍କର ଦିଟା ପିଟିସନ ଫାଇଲ କରିବେ ତାଙ୍କ ଏଗେନ୍ଷ୍ଟ ଦିଟା କେସ୍।
You have filed.
ହଁ
they will also file the petition then. You have filed against them. What are the offenses?
ଦିଟା ସେଇ ମାଷ୍ଟର ଟ୍ରାଇବୁଲ ଆଜ୍ଞା।
Same 354.
ହଁ ତ୍ରିପୁରା ମାଷ୍ଟର ଟ୍ରାଇବୁଲ
354.
ଏଇଟା ହେଇଗଲା ମାନେ ସେମାନେ ସାଇଁକିନି ଆସିବେ ଦିଟା ଫାଇଲ କରିବେ ସରିଯିବ ଆଉ।
27.
Yes.
Here, madam, the petitioner has challenged the order passed by the and Special Judge Vigilance Bhubaneswar, rejecting his application filed under section 239 Criminal Procedure Code.
Yes.
Brief facts of the case.
Lordship permits me not may submit notes. Lordship, I already heard this matter. Lordship wanted me to take instruction. I have now equipped with the charge sheet copy, my lords. All the matters there, but I'm a bit scared of Mr. Rahul. Can it take on next week, lords?
Fairly conceived. And the volume is also big, so therefore he'll read it. I understand it. Please see that on the request. And the interim arrangement made on 17/1/2025 shall continue. Yes. The first week of the 7th year. Yes.
28.
28 Belgium measurement was on bail on 8/9/21 and NBW was issued on 5/1/2023.
Okay. Yes.
29.
That is my lord. NBW order dated 27/2/2021. My lord, in this case, the petitioner did not get bail by the arresting officer. In the meantime, the NBW was issued.
Issue NBW 27/2/2021. Okay, 1000. Yes.
30.
And in this case, 41 was compliant, but the NBW was issued on 1/5/2025 for 14/4/2025.
24. Yes.
31.
Belgium matter. Bail on 11 July 2024. NBW on 12 November 2024.
32.
Well, the petitioner has been charge sheeted under 399/402/25(1)(b), capital B and small b and 35 of the Arms Act in a case. My lord may kindly turn to page number 23.
Yes.
Your lordship may see heard, peruse the case records and the above referred submitted case diaries. On perusal, it reveals that the above named accused persons are allegedly involved in the commission of the present crime. It is seen that in avoid the police arrest, they have absconded from the residence as well as the locality.
What do you want? NBW?
Yes. Well, here question is that such an order cannot be passed by the.
Forget about now. Now I'm setting aside. You go on. What?
Setting aside, and I may be granted bail because that is the view of this honorable court in. Kindly see these two judgments.
Order dated
10/4/2023.
10/4/2023.
My lord may kindly see this judgment.
I will not.
No, your lordship may kindly.
First of all, go and appear and move application. I'm giving that relying upon this judgment.
Yes.
Relying upon.
And parity, my lord, all have been granted bail.
You do whatever before to them. Subject to citizen appeal.
So, Lordship, may kindly note this, yeah.
The NBW issued by order dated 10/4/2024 by the
23, my lord.
JMFT2 Bhubaneswar, MTT case number 7834 of 2024 in state. It is open for the petitioner to move calendar and move bail application. It is also open for the petitioner to urge all the points as has been in this petition or accepting bail, including the ground of clarity and the meaning of the reliable judgment of judgment reporting 2007. Elect 8 2 OLR 148.
And another, my lord, update.
One judgment.
Yes.
Who stops you? You can move up bail application, you cite any judgment you want.
Grateful.
Unless I say it's not prevented. Yes.
My lord never prevents us.
No. You can move application, yes.
Grateful.
33.
My lord, I have filed this application, my lord, IA for modification of your lordship's order. Your lordship, that two cases are there, my lord, tag of case, two cases, my lord. Your lordship had BLAPL 6751 in first case, was pleased to pass the order on 19/9/2024.
Yes.
In column, my lord, IV4, that condition, my lord, he shall be released on bail subject to verification of similar type of antecedents.
You have gone to Supreme Court challenging this order?
No, my lord.
In second matter, it seems.
No, my lord.
Wait
I have
till outcome of the suit. Simply adjourn.
My lord.
Simply I am adjourning because in the second matter, the order of this court is being challenged in the Supreme Court. So wait till
I have
yes.
no instruction, my lord.
Next.
35.
My lord, in first matter, your lordship.
No, they are related matters. Yes.
My lord, it will simply adjourn, my lord.
No. Adjourn for another 2 weeks. Yes.
My lord, I am in custody since that date, my lord. I am in custody. I pray, my lord, next week. In the meantime, I will obtain instruction from my advocate.
You if the matter is listed before Supreme Court, you tell me.
Yes, my lord.
I'll list it after see the first second week for the 8th.
Specific date.
35.
Yes.
I filed a miscase for restoration, my lord.
Where is the order by which your petition is dismissed?
39/2022. I have not.
Where is that order?
I have not annexed, my lord. I have not annexed.
You are seeking recall of a particular order.
Well,
You have not annexed that order. Where from I will get that order?
sorry, madam.
Then you have not filed that order which you want
I'll
recall.
file it, through an affidavit by tomorrow.
How much delay?
90 days delay, my lord. Let me see.
90 days.
My lord.
Yes. 90 days delay, it is dismissed in default on 30th November 2022 for non-appearance. Writ
33,
petition.
35.
In help of the petitioner.
My lord.
Yes. What are the grounds you have given for?
Due to illness, my lord. Brief was transferred. Thereafter, the then council was not filed wakalatnama. Matter was dismissed for default, and thereafter, petitioner is suffering from.
The IA number 16 of 2022. You know, to be application 50 of 2023. has been filed seeking recall of the order dated 3C now passed by the coordinate bench in WPC bracket OA number 361 of 2019, whereby the petition was the petition suffers a delay of 90 days. Delay of 90 days. Therefore, an application interception 504 Limitation Act has been filed inter India static letter Paratri etc. For the mistake in the application, the same is allowed. The WPC number, WPC OA number 631 of 2019, with respect to its original file, leaves the resolution before the resolution. But next time when you challenge, you at least file that order. Yes.
36.
36, my lord, kindly not pressed.
37.
Your lordship directed for mediation, and although the petitioner is not an in-law member, participated in the mediation, and the 3 times mediation proceeding was conducted, and finally on 11/2/2025, it was dropped. This is a mediation because they did not participate. The opposite party did not participate. It is only the case, only the against out of the protest petition, 1cc case was filed by the opposite party, and the police submitted the final report. After that is the protest petition, then the cognizance was taken, your lordship say annexure 5, which is actually the petitioner is not an in-law member, and she is the president of the short stay home, this Nari Sadan Bhavan. She allowed the opposite party number 1 for the shelter, but only belongings was submitted, and the was handed over through Jimanama, everything. And the police also submitted the charge sheet, everything, final report, but only intentionally filed a 1cc case, and 1cc case also, this was also final report was submitted by the police, and there a protest petition. Out of protest petition, the magistrate taken the cognizance, my lord, is a petitioner is not in-laws member, and the 498A, your lordship see.
Who is appearing for the opposite party?
My lord.
Who is appearing for the opposite party? Yes.
Opposite party number 1, your lordship. 5, annexure 5.
All right, but anybody is appearing?
And only because of she has been made a party, the cognizance taken against her. Your lordship see, that is the annexure 5, this is the 498A, 323, 506, 124 IPC.
Nobody has entered appearance.
Not appearance, they are not coming. In spite of the notice sufficient in the also mediation.
That is not for the party number 1 to 4.
Petitioner is being harassed.
Through IIC, yeah? Through IIC, which police station? Through IIC, Sahadev Kuntan. Okay. This is the matter.
Well, or interim order continue because
yes.
Only after vacation, my lord.
Yes.
38.
For extension of time, my lord, lordship directed to appear before the trial court within the stipulated period, but the petitioner being an old man, 17/12/2024, petitioner was directed to appear on or before 31/12/2024. Okay. For the release of the time, also करके it's made clear that no further extensions are needed.
59.
I may be permitted to move this.
Yes.
Before taking your lordship to the facts of the case, let me give you a background, my lord. Earlier, the petitioner was before this honorable court. This is against a rejection of a discharge petition, my lord. Earlier, we approached this honorable court, and Honorable Justice Rautra was pleased to pass a judgment. Against that, we went to the apex court. Apex Court, my lord, decided the matter. Did it in additional affidavit.
Yes.
Lordship will see, we are not inclined to interfere with the impugned judgment and order passed by the High Court. This special leave petition is accordingly dismissed. Interim order stands vacated for 2 years. However, it is clarified that the contentions raised by the petitioner accused with regard to the competence of the officer lodging complaint is kept open. This arises out of an offense cognizable under the MMDR Act. So section 22 says that it is the authorized officer who is competent to file the complaint in this case. What happened in this case, my lord, that there was I was a lessee, my lord. Then it is not an allegation that in violation of section 4, I extracted certain things. Your lordship knows about the Saha Commission and Common Cause. So excess mining penalty was levied and that has been paid, my lord. That chapter is closed now. Whatever I filed a petition for forest diversion of forest land to be broken up, my lord, under section 2 of the Forest Conservation Act, and it was pending. Then during that period, my lord, the initial lease period expired. But the lease was not renewed because of the pendency of this forest proposal. But I was given a temporary working permit for mines.
In non-forest area.
In non-forest area. I have never gone into the forest area. Then, and thereafter permission was given, and it was given for a period of 10 years or co-terminus with the lease.
Yes.
Co-terminus with the lease. But the allegation is that the permission given under the Forest Act will date back to the initial period of the lease, not prospective. Then subsequently the lease was renewed and other things. Vigilance conducted an inquiry. And vigilance, after conclusion of the inquiry, filed a charge sheet and cognizance was taken. But vigilance, you know that there are 2 circulars governing in the field.
Yes.
2009 and 2010. 2010 is a notification under section 4 of the CRPC.
Page 460.
Page 460 is the notification.
460. That 2009 notification is at page 460. 461 is the 2010 notification.
Yes.
They would not be Hey, 461 is 2010.
Yes. 9.
2009 Dakota. That 460 is 2009.
Yes.
Whereas the government, may I place it?
Yes.
Whereas the government of Orissa has been considering dedication of original powers of detection, seizure, investigation, prosecution on the provisions of MMDR Act 1957 and OMTC Rules 2007 to the Joint Director, Deputy Director, Mining Officers deputed to state level enforcement squad for checking illegal mining to exercise such powers all over the state.
Yes.
Now, therefore, in exercise of the powers conferred under section 22-23B of Mines and Mineral Development Act 1957, the state government have been pleased to authorize the following officer to exercise the powers of detection, seizure, confiscation in connection with the illegal mining activities covering the entire state
The
of
officers are there, director of mines.
Yes.
Orissa,
Yes, yes.
yes, the joint
Yes.
director and all. Yes.
Mullah.
Thereafter, next.
So, 2009, we have no conflict. Then came 2010, Mullah. 461.
Yes.
In exercise of the powers conferred by Clause S of Section 2 of the Code of Criminal Procedure 1973, the government in Home Department has issued the notification by the order dated 7th August 2004 specifying the offences which can be investigated by the vigilance organization. Your Lordship, kindly mark the word which can be investigated by the
vigilance
organization. And this, your Lordship, also kindly take note that this notification is the Department of Home notification,
Yes.
under the CRPC. It is the earlier notification was by the Department of Mines. This
and here it is. It is team.
As per
MMDR Act is included.
As per Clause 1, Schedule 2 of the notification dated 7th August 2004 of the Home Department, any other particular offence or class of offences that may be specified by the state government from time to time can be inquired into and investigated into by vigilance. During inquiry investigation of the allegation on illegal mining, it is felt imperative that the other section of IPC, in addition to sections mentioned in Schedule 2 of the above updated and the provisions of the Act and rules mentioned below, may be applicable for the purpose of investigation of the case.
Yes.
So, the
Last,
then we know that Schedule A, that is a 15
15 and 19.
And 19
Yes.
The state government do hereby empower the officers and the above rank of inspector posted under the Director of Vigilance Orissa to conduct investigation, inquiry, take legal action under the provision of IPC, other relevant act and rules pertaining to the illegal mining in the state, and file charge sheet final report as it is applicable after obtaining approval sanction of the competent authority as and when required in the corresponding act and rules. The devolution of these above power shall be limited to the purpose of taking up inquiry investigation into the alleged mining activities referred to by the state government or till the latter withdraws the same. So the entire notification of 2010 is relating to the
inquiry and investigation.
Inquiry and investigation. Now, your Lordship, may kindly have a glance to section 22.
Section
of the MMDR.
Which page? Page this in the book.
Section 22.
Page?
Not a boy.
Same book.
Page 35.
35. Yes. Section?
Section 22, my lord.
Yes, 22. I'm there. Yes. Yes.
May I please?
Yes.
No court shall take cognizance of any offence punishable under this Act or any rules made thereunder, except upon complaint in writing made by a person authorized in this behalf by the central government or the state government.
Yes.
Authorization is 2009.
Lord, authorization is
2009 notification.
2009 notification.
Under section 22.
Under section 20.
Yes, 460.
460.
File.
460. Obviously. Now, my lord, there are three decisions of the state, this High Court, my lord. One by Justice Pujari, one by Justice Panigre, and another is by Justice Parija, my lord. At the relevant point of time, my lord.
Yes, first one. Para, which para? Para.
My lord, the relevant part I will place in detail, my lord, for today, my lord, at least for the background of the case and to appreciate, my lord.
Section, paragraph 11.
Paragraph 11 onwards, my lord. Relevant paragraph is paragraph 14.
Here, my lord, I have flagged it out. A, B.
You are repeating?
Okay. The judgment has been flagged out. Flag A.
Are you ready?
Are you
ready with this matter?
Ready. There was happening that particular case against whom they.
No, I'm talking about this matter.
This matter I'm not.
Ready?
Take some time.
Yes.
So judgment question
Judgment
Yes. The first judgment, which paragraph?
The paragraph 14, my lord, your receipts.
14. Okay.
Have a kindly glance, my lord.
Yes.
I will come detailedly to the judgment to understand what is the crux of the matter.
Yes. 14.
Yes, sir. Has your lordship?
Yes, I got it.
The law thus is settled that it shall not be illegitimate on the part of the police to investigate a case involving offense under section 21 of the MMD Act. But when it comes to the question of taking cognizance, no court shall take cognizance of such offense unless and until a complaint in writing is made by the person authorized to do so in view of section 22 of the MMD Act. In the present case, admittedly no complaint as of the having been filed, the order of cognizance of the offense under section 21 of the said Act is held to be illegal. But there the vigilance filed the complaint and cognizance was taken. My lord, it was challenged. But then detailing, analyzing the Surendra Kumar's case and others, they came to the conclusion this, my lord.
Yes.
Then, my lord, the second judgment is Justice Panigre's judgment, my lord, Nandlal Rungta.
Yes.
Versus State of Odisha.
Which paragraph?
Well, that time coming along. But this would be relevant in the context of Justice Rautr's earlier judgment in this particular case, my lord, wherein we have gone to the Supreme Court.
Yes.
And that Justice Rautr's decision was also taken note of by Justice Panigre. Let me place it.
Para 19.
Para 23.
19 now.
19 onwards.
Yes. 20. Yes.
A conjoint reading of the above mentioned sections draws this court's attention to term person authorized. The wording of section 22 therefore means that cognizance cannot be taken by any court unless the complaint is submitted in writing by a person authorized. Thus, the court cannot take cognizance of offense under the MMDR Act if the complaint is submitted by a person who is not designated by the central or state government to a person authorized. Furtherance, apart from the bar placed at the stage of taking cognizance, section 24 seems to place an embargo on who can enter, inspect, survey, take measurement, weigh, examine working actual or prospective mine under this section also. The person who can investigate or inspect the mines has to be a person authorized. The surprising section, your lordship may skip over it. Then come to paragraph 22. 21, my lord. However, another important point that arises for consideration is that upon a bare perusal of section 22, read with section 24 of the MMD Act, is that the person authorized must be so authorized at the time when the court take cognizance. This issue was deeply delved into by the Honorable Supreme Court in Jones versus State of MP, wherein the Honorable Supreme Court was of the opinion that in order to not attract the bar under section 22 of the MMD Act, the only relevant consideration was whether the magistrate was taking cognizance of the offence based on a written complaint by a person duly authorized at that point of time to file such a complaint. The Honorable Supreme Court in S.R. Sukumar versus Sunand Raghuram was pleased to held that cognizance therefore has a reference to the application of judicial mind by the magistrate in connection with the commission of an offence and not merely to a magistrate learning that some offence has been committed. Only upon examination of the complainant, the magistrate will proceed to apply the judicial mind whether to take cognizance of the offence or not.
Yes, I got it. And just for judgment, para 16 and 17.
My lord, paragraph 23, my lord, is the earlier case that I approached.
Yes,
Jitendra Patnaik.
I said ready.
So there also, there held that even though investigation power can be inferred from the notification 2010 notification, but the person authorized will be 2009 notification.
Yes.
Then, my lord, Justice Faridaz.
Yes, I got 16, page, para 16, 17.
So in this background, now let me place the facts of the case. Lord, your Lordship, may kindly see the rejection order first.
Yes, ma'am. Rejection order.
Yes. The facts, I need not develop in the facts because the Supreme Court, you went and that part is closed. Now only the question of the competency. Show me that part.
That is right.
Facts I need not go into.
369.
Only show me that part. Section 22.
In case of promise of paragraph, rejection.
May I place 370 page, draw your Lordship.
317.
370.
370, okay. Yes.
Has your Lordship got it?
Yes, I got it.
In the present case, as per prosecution allegation, the mining operation was continuing till 31/7/2009 by Jitendra Patnaik. The working permission granted by the government of Orissa was continuing till 24/12/2004. Even without clearance from MOEF, the mining operation was continuing and MOEF has granted permission in a subsequent date for the period of 10 years up to 3/9/2008. Your Lordship will kindly see, I will take your Lordship to the permission itself.
No, this is again on merits. Merits I can't.
No, merits means the interpretation of the permission.
Yes.
It cannot relate back to the past period.
Yes.
Unless it is specifically spelled out. The will alleged to have been executed by Bansidhar Patnaik was found to be a fraud one.
Where are you reading?
Is the 370.
Okay.
Yes. 21. In case of Ramesh
In case of Ramesh Ogral and others versus State of Orissa, our Honorable High Court has been pleased to quash the cognizance under Section 21 of the MMD Act as the complaint was not filed by the authorized officer. In the present case, cognizance was taken on 11/6/2013 under Section 13(2)(379) of the MMD Act, Section 3 of the Forest Conservation Act, Section 58 of the MCD rules, and the said order has not been challenged before any higher forum. Now this court cannot recall or review its own order.
Yes.
Day in and day out, my lord, where it is challenged, my lord, your lordship is telling that raise all these points at the time of priming of charges. And it is a very strange thing that if cognizance is not challenged, then your right
You
to
can't move up.
right to under say section 239.
That observation is neither here.
The Orissa Gazette dated 14/10/2010 empowers the officer above the rank of Inspector of Police under Director Vigilance to investigate, inquire, and to take legal action under forest conservation and mining relation such and such
Submitted by the Inspector of Police
pertaining to illegal mining and to file charge sheet. Final report after appealing of this charge sheet was submitted by the Inspector of Police Vigilance Cuttack, and he has been authorized to investigate and submit the charge sheet.
Yes.
At the stage of consideration charge, the court has to sift the evidence. Then it takes cognizance without answering that whether the power to investigate is the power to file complaint or not. परमिशन तो ये देखे तो
Yes, I got it. Yes.
Lordship can see the order of the Hon'Ble Apex Court. That is,
yes, not inclined to entertain, but however, it is kept open. The
kept open
doesn't mean
that it file 482.
Regarding the competency of the officer lodging the complaint is kept open.
When it will be decided at trial, not in 482 at pre-trial stage. It's a factual aspect. It's to be adjudicated.
That is the factual.
And another aspect is, your lordship, what 22 says, MMDR Act, in respect of cognizance, with all respect, so far as cognizance defined by the my Lord Justice Panigrahi, that is related to complaint in 200 case, section 200. We are not on 200. We are dealing with the commission of a non-cognizable offense in relating to that that is warrant cases. So 200 and warrant case is something different. And 156 says of CRPC.
Yes.
Police officers' power to investigate cognizable cases.
Yes.
That is in respect of complaint case, it will not applicable. It's in respect of warrant cases.
Yes.
Any police officer in charge of police station may, without order of any magistrate, investigate any cognizable offense which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provision of chapter so and so.
Yes.
No proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered. So we have conducted investigation under section 152. Initially, FIR was registered.
156(3).
156. Then your lordship kindly 22 says in respect of cognizance. So during when the cognizance was taken, we have accorded the power. He has not challenged that notification. So rightly cognizance has been taken. So
the cognizance order is not challenged.
Cognizance order was not been challenged. No notification was challenged. Now at discharge says they challenge they're uttering that he has no power, they had violated 22. So 22 will not be applicable here because we have got the power at that by that time. So rightly, my lord has in the impugned order, cognizance was taken 22 as per 22 of MFDR. Cognizance was we have power and magistrate has taken we have filed the charge sheet and cognizance was taken. So what is wrong in it?
When is the FIR? FIR is on
FIR is on 18/11/2009.
FIR.
Notification
FIR 18
11/2009.
2009.
Notification 14th January 2010.
And
charge sheet was 11
charge sheet
11 June 2023. No, 13.
2013.
13. And
Page.
Charge sheet. Charge sheet that is last page, that is 175. It starts from
Yes. First notification is 460. 460 notification.
That to that is 2009.
By 9.
final form, that is charge sheet 6/2013 page 89.
No, first notification of mining department is 19 December 2009.
9.
And the second one is by home department.
By home department.
By home.
Under section 2.
Department.
Yeah.
Is 14 January. January 2010. Okay.
So your lordship, another aspect your lordship kindly visualize. What is the purpose of bringing this notification? What the object? The objective is to prevent illegal mining. So on the ground of all those technicalities, we cannot allow perpetuation of that illegality or corruption.
Yes.
And the intention your lordship knows that in the constitutional based judgment in the A.R. Anthony case, when there is two views are possible, the laws which relates to preventing corruption, that should be prevailed. Otherwise, the purpose of the object of law will be defeated.
Yes.
So, accordingly, with all respect, that the judgment relied by this court is not applicable to the present contest, and there is no illegality in the impugned order so far the power.
What about the third judgment?
So far the third judgment is concerned, I have not gone through that. He is serving the copy right now.
Para 16 and 17. Here, this is also
no court shall take cognizance.
Yes.
Except upon a complaint written by competent authority or person authorized in this.
Come to the first page. The accused petitioner filed this petition paying for quashing of the FIR. There was an FIR.
That was an FIR. Here he has challenged he has challenged the cognizance order. He has not challenged the cognizance order. Here he has not challenged the cognizance order.
Yes.
He is filing discharge petition. And now he has changed the prayer. He has changed the prayer to quash the proceeding, which is not possible in one way. There now he adopted the other way.
What is the prayer in this petition?
Quash the proceeding. FIR, quash the FIR. Your lordship can consequential FIR and consequential proceeding at this stage. When Honorable Court was not inclined to interfere in the impugned order and left it open to adjudicate the issue in appropriate stage. Appropriate stage is not this stage.
Appropriate stage
Not number 82.
appropriate stage likha hai.
That means
it is not there, but see, the problem is, see,
Supreme Court judgment.
On merit it is tested by the Supreme Court. Supreme Court is not interested.
Merit we are not addressing your lordship on the merit.
What is your prayer now?
My
Your prayer
prayer
is asking, indirectly asking the same thing. Asking for quashing of the charge sheet.
But since
You are not challenging that notification.
That is no necessity to challenge because there is no conflict.
But how can I allow this prayer?
My lord,
In the face of the Supreme Court
your
judgment?
lordship will see all these three decisions, except Justice Parijar, those two decisions are regarding cognizance.
After filing of the charge sheet.
After filing of the.
But you have not challenged the cognizance. You have allowed it to attend finality.
No, after those are cases after filing of the charge sheet. So, if the cognizance is bad, then the question of charge doesn't arise. Well, am I clear? Madam?
I understand it, but the charge is framed and you went to Supreme Court said that I'll not enter. I can't upset it indirectly.
Rejection, but the Supreme Court says that rejection
Indirectly, for the lighter side, Supreme Court says, invite an adverse order, come here. We'll decide. That's what Supreme Court says.
Your Lordship may kindly have a glance to another decision of the Honorable Apex Court.
See, the observation, it is open means whenever it will come to us, we will decide it. That's what the observation is.
Yes.
And how will you go there unless you invite an adverse order? That's the observation.
Your Lordship may kindly see. What I understand is that this proposition is preposterous, that unless you charge
no, that's right. You
challenge a cognizance order, you cannot file a discharge petition.
No, you can do that. There is no problem. The problem today is the charge order you went to Supreme Court.
Yes.
It is confirmed.
Rejection of the charge.
It is confirmed. It is confirmed. How can I upset it?
Then
Today by quashing the charge itself.
If your Lordship holds that it is by a competent authority, that is the end of the matter. I have no case.
Touching to the charge sheet.
If the complaint is by a competent authority, authorized officer, then I have no case. If your Lordship holds that 2010 notification doesn't authorize the officer to file a complaint, but only confines it to investigate and file the charge sheet, then the question is, I have a wonderful case, my lord, in view of the observation.
Wonderful case for Supreme Court.
With all respect, my lord.
Wonderful case for
So
Supreme
here-
Court. It is open it can also be interpreted in such a manner, the observation. In the right case, we will decide it, not in your case.
I don't think so.
It is kept open to be decided in the right case, not in your case. Insofar as your case is concerned, it was dismissed and it's confirmed. That's the idea of the question of law kept open. Means not kept open in your case.
It is
kept
not
open to be decided in the appropriate case.
question of law is kept open. It is specific to this particular case. However, it is clarified that the contention raised by the petitioner with regard to the competence of the officer lodging complaint is kept open.
Me only.
It is so far as the petitioner is concerned, my lord. It is not a question.
You're right there. You can raise this point.
Yes.
In this proceeding, you can raise this point. But at what stage?
My lord.
Anyway,
My lord, your lordship.
you have a right to argue. You have a right to move application. Because the observation is
Observation is so far as observation, with all respect, my lord.
My
What
lord,
prevented the Honorable Supreme Court
My
to
lord,
pass an order interfering that order? That point was there. My lord was not inclined. That is the clear order. And it was kept open means not at this stage.
Not question of
It is to be
open.
once the refusal of rejection order, discharge means it charge is automatic. It's to be framed and trial to be proceeded, and it will be adjudicated during trial, not at this stage, not in 480, 397 level, 482.
yes.
A Sanjay case is something different. Sanjay case is something
That
different.
Supreme Court
Not
judgment.
applicable to this.
Supreme Court judgment.
69,
Not be applicable.
Paragraph 70.
69, 70.
Paragraph 70.
My lord, your lordship may not close it, my lord. My lord, let me place those judgments in detail. Your lordship keeps it parted to any other date. There is no problem.
Perfect. Keep it going.
Because I want to, but my contention of Mr. Mahana is that the authorized officer under the 2000 notification is the authorized officer to file complaint, which has been specifically dealt.
But what he says is, once the Supreme Court has
that is altogether different thing.
No, once he says that the framing of charge is correct, then the consequence is the trial. Consequence is the trial. I can't curtail the trial at this
It
stage,
is a question.
deviating from the Supreme Court.
It is a question of maintaining of the cognizance under the provisions of the Act. So the very proceeding will be vitiated if your lordship permits this cognizance.
But in the same time, Supreme Court has upheld the order of this court saying that charge is
Charge framed in. There is the charge has not. Discharge application rejection has gone.
What is the consequence of that order?
The
Consequence
charge
of that order is
the matter
charge has to be framed and you have to make the trial.
And to proceed.
And again the consequence of observation is after the trial only you can raise this.
Including the issue of the competence.
Go into the detail to those two judgments of this Honorable Court and the two judgments of the Honorable Apex Court. Any date your lordship may fix.
Get the copy of SLP.
Yes.
Get the copy of SLP.
All right.
Whether you have raised these points or not.
Yes, that was there.
Yes, ma'am.
Let us
That was there.
get it. Get
Yes,
it.
yes, madam. I will.
Just pass on to me.
My lord,
I will pass it.
A short prayer, my lord.
Yes.
Item number 52, my lord, is appearing for the petitioner and for the opposite party. It has been already settled. Joint affidavit has been filed. My lord, was the last occasion said, presence of parties are not necessary. One is a doctor and other.
What are the offences?
Minor offences, husband and wife.
498A.
Lordship.
52.
498, 332, 294,
Sent for mediation. In the mediation, rupees 20 lakhs and all ornaments, house, everything was given by husband. So, and the divorce case.
Mediation successful.
Yes, mediation
And I
success.
think
That basis you have to do it.
Yes, Lord.
You need not come, I'll do it. Yes.
Your lordship is putting my case
23 minutes.
not on 23.
No, on the either 8th or 12th. 13th.
8th.
8th.
I'll be absent.
Hmm?
8th I'll be absent.
Okay, 13th.
12th.
12th. Substantially heard, parted. I got it. Yes. 54.
52, Lordship.
So item 18.
Item 18, my lords. My lords, here the present petitioner, there is no allegation in the FIR against the present petitioner, except only one line. My lords, the case is that the elder brother of the present petitioner was in love with a girl and they both eloped to Rourkela. The only allegation is that when the father of the victim went to the house of the accused to find them, the allegation against him is, he said, their consequences. That is all. And in this, everyone's statement has been examined. They have not mentioned about me. I have given the deposition. My lords.
What is your name?
My name is Sangram Kesari. So I'm at page 29, my lords. Page 29, brief facts of the case. On 24/1/2021 at 10:53 p.m., complainant Viswajit Sahu reported at PS that about 6:30 p.m. his daughter Jyotirmayi Sahu gone to attend the call of nature but did not return. The complainant and his family members searched for her but could not trace her. They came to know from reliable sources that Bikram Kesari Sahu, my brother, had kidnapped their daughter forcibly by the help of Sobhagya Bhoi of their village with ill intention. When they went to the house of the accused to know whereabout the victim accused persons, namely Raghunath Sahu, the father, Golab Sahu, mother, and Sangram Kesari Sahu, brother, abused in filthy language and threatened for dire consequences.
Yes.
Well, they also did not come to the house, our house. Had they been in our house, they both went to Rourkela and the girl was rescued from Rourkela. This is only allegation. I have given the depositions also, my lords. The informant's deposition, the victim's deposition, none of them mention about me, my lords. He was only 20 years old then. Now he is 25. He is applying for government jobs. And everywhere he has to face this declaration.
What happened? Whether your brother is married?
My
The victim.
The brother has not married the victim, my lords. No. That trial is going on.
Has been rescued.
Yes, yes, my lords. They were in consent, my lords. After they went out, this has been done. Even
What's
the
the age of the victim?
then it was 16 years, my lords. At the time of FIR.
The POXO is also there.
My lords.
POXO is.
But so far as this present petition, my lords, no role, my lords. Absolutely no role. Only in the swap of family members, his name is mentioned.
My mother had seen that accused Vikram had kidnapped.
The statements I have given, my lords.
164 statement given.
And out of 22, most of the witnesses is already examined, case is
Already examined.
Well, that's all. I have given the depositions.
Oh, no. These are deposition of 161 statement.
No, depositions on it.
Oh.
And none of them
I thought
mentioned
161.
No, my lord, these are the depositions.
Then the trial court will decide how will I appreciate the
My lord,
evidence.
the trial with the intention is that, my lord, the trial
Appreciate the evidence. You came at so late. I am under the impression that these are the 161 statement.
No, my lord, these are the depositions. My lords, I understand so far as the present accused is, the main accused is concerned.
Maybe, but how can I see evidence is going right?
My lords, it will culminate into a acquittal only, my lords.
Then that's good. That's what I'm saying. You will be acquitted.
But my
There is
lords,
no evidence against you.
will take
But I can't acquit.
My lords, there is, my lords, on the face of record as on today, my lords.
I can only say that expedite the trial. That's all. That's the best relief I can give in this petition. Beyond that, I can't do. I was reading all these things thinking that it's 161 statement.
Deposition.
Oh, I can't.
Let's make expedite.
कितने charge sheet witness total? 22. How many of them are examined?
My instruction is, my lords, 12 of them. All the.
Oh, you came so late. You should have challenged in the beginning.
My lord.
In
Now
fact,
they
there is
never
no-
knew that this will be the consequences. When he's applying for all government post, OPSC everywhere.
Why have we waited? See, the FIR was registered way back in 2000.
He's a very bright boy, my lord. That is why his parents, everyone is
That's
concerned.
right. You should have, because there is no allegation as such
My
against
lord.
him.
And
was
this
wondering.
against him, it is only 294 and 506.
What is that? There is nothing, not a single whisper. But unnecessary, you face the trial.
My lord, sir. My lords, even after the trial, my lords, I will cite judgments, my lords, even if after the trial is.
This is one of the accused in FIR number Narsingpur PS case number 15 of 2021. The investigation charge sheet was filed in the present case on 24/1/2021 for alleged commission of offences transferred under section 363, 294, 506, 34, 366, 376 2 and 376 3, 354 D IPC read with section 6 and 17 of POCSO. There are 22 witnesses have been cited by the prosecution in the charge sheet. Out of them, 12 witnesses have already indicated. Mr. Hon'Ble and counsel for the petitioner taking me to the depositions of the witnesses submits that none of the witnesses so far examined by the prosecution has uttered a single word against the petitioner. Moreover, apart from that, in the charge sheet, even in the charge sheet, the education of the petitioner, there is no education of petitioner. Therefore, we seek indulgence of this court, question of the FIR. Since the trial is at the advanced stage, and exercising and the jurisdiction of this court, the jurisdiction of this court, and 482, this court is not inclined to scuttle the trial abruptly. Rather, regard being had to the nature of evidence which has come on the court and the fact that the petitioner is a young boy, what is his age?
26 months.
Petitioner is a 26-year young man who is aspiring for
government job.
I feel it appropriate to direct the trial court to see that the trial is concluded as possible. Preparation is going to take up 6 months and years.
Grateful.
24.
And in this case, I am challenging the second complaint petition in favor of protest petition after filing of the final report in as a false case. And the allegation is that complaint petition is that one, that in page 30, the in complaint document 2, you are claiming that the accused person that petitioners are taking money from him as borrow basis. And when he was demanded to return, they said he was not returned and threatened the allegation. That was the same was first complaint petition was forwarded in 156.3, which was registered as a PS case, and the police has submitted final report. In final report in page 40, the police has submitted during investigation case revealed that complainant Mahadas was living in a rented house in village Urali in 2020 to look after the construction work of his sister house, and Sabita Sahu are a grocery shop. Sabita Sahu is the mother of the present petitions, situated in the village Urali. She used to provide good food to laborers working nearby the area, take money from its return. He has 4 daughters, namely Kasturi Sahu, Jambada Sahu, Rashmi Rani Sahu, Vishtusri Sahu, and 1 son, namely Vignesri Sahu. They are the father of the petitioner and his children, sir, died since in his early childhood, my lord. His mother was facing hardship to maintain the children, my lord. And taking the advantage, the said Mahadev Sahu, my lord, was demanded to Mahadev Sahu forced to Sabita Sahu, the mother of the petitioner, to marry minor daughter Rutisru Sahu, even though she was already married. When he was not agreed with the same, he was lost false case against him. Earlier, 1 case was registered against him due to harassment of the petitioner. His mother has registered a case that is an NS1.
Yes.
And therefore, the protest petition file and the due to initial settlement was.
Just see the protest petition. Let us see the protest petition.
In page 53, the initial statement.
Yes. What are the allegations against you?
Against you. The Mahadev Das, the complainant, my lord.
Priyambada.
I am the informant.
Priyambada and Kasturi.
Yes, my lord.
Priyambada and Kasturi. Yes.
That the land of my sister situated near the house of the accused person, while my sister was constructed the building, I was looking after the newly constructed house of my sister. The accused person.
Where is the protest petition?
What's this?
Only annex the initial statements.
Protest petition is not there.
Protest petition is there, but I have mentioned the index. But unfortunately, has not attached in the petition, my lord.
You are challenging cognizance of file a protest petition.
But in protest petition, same sort of allegation due to improper investigation of the police. That is the case protest petition was filed. That is the only same allegation. In the final report submitted by the police, my lord, that is the important thing.
That's right, but thereafter protest petition is filed.
Yes, my lord. That is.
Let us see the content of protest petition.
In the Supreme Court has protest petition. Yes, my lord. 54.
Now cognizance is taken. Where is the cognizance order?
Cognizance order in page 51.
42506.
Yes, my lord.
I'll issue notice. Let us see it. Let them.
In the Honorable Supreme Court has in a case of reproduction has stated that the second protest petition similar same 156 was forwarded and one.
You have not filed the protest petition. How will I know? Then
I understood, my lord. I think the case was posted to.
I don't know. Second, third. You have. Where is the protest petition? Show me.
I filed there. Unfortunately,
That so therefore, unfortunately, I will not give you interim relief. Only I will issue notice. See, you should file. See, these are the minimum documents.
That is the mistake. I have in initial index. I have mentioned.
I'll simply issue notice after.
But no course was in 23 while the case was posted, my lord.
No problem. Nothing will happen. Yes. 23. Incomplete petition still ambiguous. Yes.
25.
File the process immediately. Yes.
Posted in short date.
Yes, all right.
25.
If I with the allegation of the 354-376 allegation is there. Only FIR has been filed. No.
What is he asking?
No, nothing.
Passing of the fire.
Yes.
Investigation is going on.
Yes.
Nothing is said also. So they said that they've compromised. Huh? What are the offences? What are the allegations, Justice?
Yes. The allegation that he had the relation with the accused person and thereafter Instagram रे fake ID create करके तक photo show.
Nude photo?
Nude. Page 8.
Yes.
Yes.
Yes. Yes.
In this case, the informant is present here to file the affidavit for compromise, not wants to lead his case.
Yes.
There is a civil dispute between the ancestors.
Service is incomplete.
Upendra.
Service through IH, yeah? Service through IH. Opposite party. Let us see, I've directed the IIC to serve opposite party. Yes.
But the informant is present. Informant is present.
Present?
Yes.
Who is? Who will identify him? Let him engage a lawyer. Engage a lawyer because the allegations are there. Unless somebody identify as a lawyer, he has to file wakalatnama, enter appearance. First of all, he refused to accept notice. I don't know whether he is complained or somebody else. Let him file a wakalatnama through a lawyer so that the lawyer will identify. Okay. Although the opposite party number 2 has refused to accept the notice, however, the party the person has appeared before court. He submits that he would be engaged with the counsel on 5 leaves the matter. Yes.
52.
Lordship, it's not before your lordship filed this case for causing of the proceeding on the ground of compromise. This honorable court has been pleased to refer the matter to
What are the offences?
406, 417, 506, 34, arising out of matrimonial discord.
307, what are the allegations?
307 टा omit ही जाइए lordship.
Omit ही?
हाँ, charge sheet कट जाइए.
Okay, right. Where are they? Are they present?
Lordship, no lordship. On last occasion they were present.
They were present?
52. Yes, sir. On last occasion they were present and my lord dispensed.
Where is that order?
Order में senior थे के भी गले.
Show me the order. Last occasion, how do you know?
No, because that day your lordship they have filed an joint compromise affidavit.
Where I have said that they need not appear.
Last date. Order mediation report extension for this honorable court will my lord कही
Oh, there is a mediation report.
Is not required.
Is there any mediation report?
Yes, your lordship, that is on record.
Why are you not saying? In mediation they have participated?
Yes, in mediation they participated and mediation it was finalized. As per the mediation report, they have filed a compromise affidavit.
Who is appearing for opposite party? Have you got the money? Yes or no?
Yes, Lord.
Shall I record it?
Yes,
Okay, hello. The business actions of opposite party number 2 for the FIR under this court issued notice to the opposite party on in this petition, if you watching for the entire criminal prosecution, we need the June 5, number 2. This court issued notice to the opposite party by the order dated 20/11/2024, and also referred the matter to the House of Mediation Conference. The parties have participated in the mediation process, and the mediation came out to be successful. The High Court Mediation Center, the letter dated 4/1/2025 is placed on record the mediation report dated 3/1/2025. The mediation reports reads the number. The counsel for the parties appearing in the counsel session for the parties conjointly submits that as per the mediation report, the petitioner has already paid the settle amount.
Yes, sir.
Settle amount of 20 lakhs.
Settled amount of 20 lakhs, one flat,
20 lakhs.
20 lakhs, one flat.
And the agreed.
And the return the jewelry suits.
Flat, where is that flat?
Lordship, I am giving. Divorce to be granted based on the.
This affidavit of what?
No, that is the settlement date before family court, and affidavit is already in file, your lordship.
I filed the
Affidavit dated.
where is the address? Where is the address of the flat?
That's the affidavit. You got most of the one, then put it as one of the one.
20 lakhs parties. 851
Gold jewelry return and exchange, flat already taken over.
20 lakhs. Item, all the item, as well as a flat bearing flat number B21, third floor, block B, type 2 BHK, at Vivo Angan apartment at Bhubaneswar.
Yes, sir.
The parties have also filed joint affidavit dated 22/1/2025 in Relia stating as an para 1 to 10. The mediation report has what we make part of what we make part and parcel of the council what the parties conjointly submit that the parties are bound by the terms of mediation. The obligation flows from the mediation purpose and the grant appeal to compliance. And the government has to. You filed the divorce is granted?
Yes, your lordship. Divorce granted, the DV case withdrawn, and one complaint case under 125 CRPC that has also been withdrawn.
DV case?
And that settlement did.
You have written everything here?
Yes, your lordship. In that settlement that is there.
Already there. In the joint affidavit you have.
Yes, your lordship. Obliged lordship.
I have issued notice. The allegation 66 is there and everything is there.
Lordship may see the affair. Wife, husband, peaceful. Wife voluntarily coming.
They are married.
Yes.
Investigation complete, no.
How you effect of the let them come.
I have seen it, therefore I am asking whether investigation is complete or not.
No. Other purpose, he approached the police. Lord, police has stated that this affair was written by the police people, then she has just signed.
I am asking. I am asking whether. Yes.
Let her come.
Yes.
50. Both the parties filed joint affidavit. Crossing of the affair under Annexure 1.
498A.
498A, and there is a.
They are there.
mutual,
Several cases
the the marriage has been
Keshav
dissolved by decree
Chandranath.
of
the
divorce.
capacity of this affidavit.
Keshav Chandranath, where is? Okay. Geetika? But tell Sarita to ask. Right now, I give sense of course. There is only one case or how many cases are there?
Many cases, but in capacity of this CRM that may be withdrawn.
Huh?
That
Till 10 lakh, till now DD has not solved.
10 lakh you have paid?
10
Have you
lakh.
paid?
No, no. I have not received
Achha,
10 lakh.
you have
I
not.
am for
Where-
the
Who
income.
is for petitioner? Call, who is there?
Sankar ka naam. Call karo.
Yes.
Pass over.
Yes, yes.
Kindly pass over the matter. My learned senior will conduct the matter.
What senior? Have you paid the money or not?
Today in the course of the day, I have the instruction. I will pay today.
You will pay?
Yes, ma'am.
Pay it and come. Monday, Tuesday. Tuesday. Pay it and come.
My lord, this one. My kindly pass over. My senior will conduct it.
See, you have settled the dispute.
Yes.
It is a 498 case. You have to pay 10 lakh rupees. Pay the 10 lakh rupees, I'll pass it.
Madam.
The parties need not come because it is for mediation. Do you have the 10 lakh rupees right now draft?
Yes,
Give.
Divantar.
I'll pass it right now. You have, why are you not paying?
I have
Just take it up.
instruction.
The name and all. I'll record that here right now.
Just give him draft.
Name, spelling, correct?
Yes, yes, spelling is correct.
All right.
10 lakh amount is correct.
Photocopy. Right. The petitioner, at the instance of opposite party number 2, or FIR number 4, is going to be read for allegation of the petitioner control. The let's see which one is the after investigation, charge sheet of the present case has been filed on 14/2/2024 for alleged commission of offences considered under section 498A, 294, 5065 PQ, reading the section 31 RS and 32 VA of HCST POA Act. POH. The charge has been framed.
No, my lord.
The trial court by order dated 5/4/2024 has taken cognizance of the offences before the trial could commence. The parties are very and the road right like that. The petitioner approves this court by filing the present petition seeking quashing of the cognizance. Notice was issued to the petitioner by the order dated 4/9/2024. 24. Subsequently, on 14/2/2024, the matter was referred to mediation center, High Court mediation. The parties participated, both petitioner and opposite party participated in the mediation process, which came out to be successful. The High Court Mediation Center, while letter dated 7/4/2025, has placed on record the mediation report dated 5/4/2025. The mediation report reads agenda. The petitioners the petitioner agreed to pay 10 lakh rupees towards the full and final settlement of the dispute. Today, the petitioner has handed over a draft hearing number 4 of which to the opposite party, counsel for the opposite party, in compliance with the terms of the mediation report. Both the council mediation report will reproduce as a form part of the present orders. The council sitting between parties on second. Submits that both the parties are bound by the obligation flowing from the mediation report. They also submits that on the basis of the mediation report, the proceeding arising out of FIR number so and so. The cognizance order dated so and so, arising out of the FIR number so and so. The court. We are going to the thing dancing for the questions. Okay, question. If you go see here.
69.
Here.
69 also I have compromised all of the students of Padimbar University, and during that is while staying in hostel there was some dispute, and now they have been settled lordship because
Allegation, my lordship, when the complainant was in the room of the hostel room, the present petitioner, 4 of the present petitioner entered into the room and assaulted him with a lathi, iron rod and beer bottle. And my lordship, with the name of the caste, my lordship, they used to obscene language.
All of them are in Bhubaneswar.
Yes.
Let them go. See, where is that order which I passed?
Yes, my lordship. That order I was just.
Where is that order? Can you give the number?
Yes.
I've sent those same type of incident. I've sent them to Chodar jail for 2 days.
Yes, my lordship.
They do because they are appearing in OSF, lordship civil service. It will help them in
Let them go do some social work and come.
One is qualified for
know that how the jail life.
I will get that number.
Henceforth they'll not do anything.
But lordship, because they are staying in Bhubaneswar, it will be convenient to Jharpada jail.
Where is that?
I will give that number, my lordship. Yes, my lordship.
The last paragraph, the instance of opposite party, fire number so. If you impose cost, they are young students. It is burden on their parents.
Yes.
Parents, lordship.
So better they
It
should
will,
suffer.
yes, my lordship. It will be appropriate for them.
Instance of opposite party, the petitioner,
Sorry, this we will do something.
in the present case, after investigation, charge sheet has been filed on 3 charge for alleged commission of offence under section. I said, we'll do 15 number 2. The third additional sessions judge, Bhubaneswar, by order dated 17/5/2017, has taken cognizance of the offence above and issued the NBW for the petitioners. What is this order 99?
9, only one Mukesh Sahu. Against him, the NBW was issued. Other 3 persons were appeared, my lordship.
NBW was issued against one of the creditors. And before the trial is commenced, the parties have entered into a settlement. On the basis of the settlement, the present petition has been filed. The opposite party number 2 has filed an affidavit before this court dated 11/4/2025. Inter alia stating in the affidavit you have not said anything. 2, 3, and 4. 2, 3, and 4. Nothing is said. 2, 3, and 4. The petitioner, all the petitioners and the opposite party number 2 are present in the court, being represented by their respective counsel and identified that they've also filed separate copies of their Aadhaar card to establish their identity, which are taken under cover. The opposite party number 2, where is the opposite party number 2? Who is he?
Subodh Malik.
Pratikanta Sarpati.
Item 41.
41.
41.
41 may please, my lord. But on the last occasion, my lords had directed us to implead the informant in this case as opposite part number 2. Since this is a case under section 3762N, if I'm filing the memo with a consolidated.
File their memo.
Filing the registry, my lords. No, it's one prayer.
Notice has not gone.
Because of they have not implement the victim, my lordship, that's why the notice was not.
Lords, one small prayer, my lords. Since this is a case under 3762N, the name and address of the victim cannot be reflected in the hostage. So, my lords, we have served an extra copy on the state. I prayed for the IAC to someone and IAC can of the concerned PS.
But I'm happy doing
Notice, notice of the
extra
opposite party be heard through the IAC of which police station?
Manchester.
Manchester PS. Police station, we matter. Yes.
Date.
Yes. First of all, you have not filed.
No,
and then you need a date now.
No, but extra copy.
Yes, review.
42.
DPO.
Lordship, in item 42, I am for the petitioner. The file is somehow misplaced. Old matter is
File.
allowed some.
File misplaced. You want to reconstruct.
Yeah. Your Lordship, there is a IF for further order.
Sorry?
Noting there is a IF for further orders.
IF for?
For further for stay.
In the review, what stay? How can there be a stay in the review petition?
District 140 by 2005.
Huh?
District 140 by 2001.
Application is there, where is the stay order?
Further proceeding, I was going through the.
What is the problem? Why can't you argue? You don't have a file.
The old matter, I was searching.
Stay is also very old. Then in a review petition, you got a stay, and in 2009,
the file is.
Today you are saying file is not there.
After long
Take
time.
the file from here. Take the file from here and do it. 2009 in a review petition, you have got a stay. In 2009.
Sure.
There can't be a stay in a review petition.
I have not gone through the matter, because I don't have.
Leave sheet on 6th. 6th. Then counsel for the petitioner submits that he is law to file. Want to reconstruct the same. I will tell you the order sheet on 11/1/2009. There is an entry model which has been operating since then. Therefore, the matter is directed to be listed on the 6th. Make clear that on that day, the matter will be finally done. Otherwise, if the petitioner will seek adjournment on that day, the entry model passed on 11/1/2009 can be vacated. Yes.
What is the?
I'm for the petitioner matter. I'm appealing to the opposite party number 1. The copy has not served. The petition, same petition copy has not served. Customer kindly say order dated 4/3/2016.
Yes.
There, this Honorable Court directed Mr. Sibo Sankar Mishra to appear on behalf of the OSFC. But thereafter, Mr. Rautraya is instructed to appear on behalf of the OSFC, but no copy has been served yet. So far as CMP petition is concerned, and though 2 missed cases they have filed later on, they have served the copy.
The 2002 suit is stayed.
Madam, that's it.
The suit of for 2002.
Yes, sir.
He stayed now in this proceeding.
Stayed, your lordship.
You should have collected a copy from him. Rather, counsel for the opposite party submits that he doesn't have the copy of the petition. He wants to counsel for the petition is there to supply a copy, lease the matter. Yes.
44.
Present petition is against the order of rejection passed by the district judge Cutter. The factual aspects of this case is the present.
Show me the impugn order. Show me the impugn order.
Annexure 5.
Yes. 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 Order 1, Rule 10.
Order 1, Rule 10. Yes. The present petitioner is one of the daughter of Balaram Behra, and the suit has filed for partition of their ancestral joint family property. While thus, the defendant number 1, who is Sakhi Dei, the mother, and one
Where is the suit? Where is the suit?
dispute is some of the two sisters.
Can you show me the plaint?
My lord?
Can you show me the plaint? Plaint. Can you show me? Have you filed? No.
Yes, against that, the RFA was preferred.
Where is the plaint? I want to see plaint.
Plaint has not been filed. This is a transfer brief, that's why. Plaint has not been filed.
Okay. Yes.
Yes. Against the judgment, the petitioner, the present petitioner as appellant filed the appeal, RFA, which is pending before the district judge Cutter. And the case of the present petition is that is the suitable property is the joint family ancestral property of the family, and she is the one of the daughter. Bhabhi and Lavanya, 3 daughters, have assailed the decree, and they have filed jointly the suit for partition. Thereafter, one Sakhi Dei is the mother, and one Chabi and Sobi, the 2 daughters, and two daughters have made a power of attorney against the only brother. Except these 3 petitioners, on the strength of the power of attorney, the brother Rabindra, he has sold in favor the property in favor of his minor son, and now the minor son became major, and he is alienating all these family properties with a view to deprive the present petitioners from their joint family properties. And the present petition is there. In the RFA, while the son of Rabindra, the power of attorney holder, who has sold the entire property in favor of his minor son, the minor son became major now. He sold the property some stranger persons. In the RFA, the present petitioners prayed to implicate them as party, as because they are taking.
Are you a proper party or necessary party?
They are the necessary parties as because they are the strangers and they have purchased the property, and they may change the very nature and character of the suit land.
Your case is they are the lease pendant purchaser.
Lease pendants for purchaser.
So therefore, they are necessary party.
They should be necessary party just because the present petitioners have will be prejudiced.
Yes.
Your Lordship,
Yes.
I'm appearing for the opposite parties. My submission is, Your Lordship, kindly come to page 51 of the impugned order. Page 51 of this CMP, which is
51.
the impugned order under Annexure 5. I would reiterate the decision relied upon by in the impugned judgment that at this appellate stage, the parties who are not in the original forum cannot be implicated as parties in the appellate stage because that will prejudice both the parties and that will reopen the suit. The trial court has clearly observed in its judgment that admittedly proposed respondents were not parties in the suit. Learned trial court in the impugned judgment dated 12/4/2019 in the suit has categorically held that plaintiffs
The vendors were a party.
plaintiffs
Where the vendors were
it was
party.
it was within the knowledge. The sale deeds are also marked as exhibits, and so also the GPA and the other sale deeds. And the person who is Trilochan Behra, the son of defendant number 2, he was neither a party in the suit. He was a minor, but they knew the GPA was in favor of him, and properties were sold which were marked as exhibit. Yet they never made him as a party, never challenged the sale deed, and at this stage, the suit has been dismissed for non-gender and misgender unnecessary parties. If at this stage, prior to hearing of the appeal, this application is allowed, this means allowing the appeal itself.
Where is the judgment?
Yes, my lord, I'm relying on this judgment. This is AR 1971 Orissa, page 274. Radhakrishna Chaudhary versus Radhakrishna Mahaprabhu, my lord. Para 6.
May I please, Your Honor?
Para 6, 15th line, my lord. May please?
16. Para
6, 15th line.
Yes.
It is the settled rule that of law that a person who is not a party in the original forum would not be a party to the appeal, and to add such a person who was not known to the record earlier as a party to the appeal for the first time would certainly prejudice either the newly added party or the person already on record and might necessarily involve the need of reopening the matter. My lord, the suit is of the year 2014. And at this stage, if this application is allowed, it surely prejudice us, my lord.
My lord, appeal is the continuation of the suit.
Where is that judgment I am searching? Judgment of the trial court, suit court.
They have not annexed, my lord.
Judgment of suit court is not there. Maint is not there. Nothing is filed.
On the next date, I will substitute
How
all
these
these
cases are
things.
entertained, I don't know. And this is pending since 22. Unless I see that judgment of the trial court, how will I know who are the party? Maint copy is not there. Nothing is there. I'm struggling to get all this.
Certain. On
And there is an entry model operating.
I am much sorry and
Sorry, see, the entry model is operating since 2/12/2022. This matter is arising out of an application in an RFA. The RFA is filed against a judgment. Where is that judgment? Judgment is not there. Plaint is not
judgment
there.
is here.
Where is that? Nothing is there.
The original judgment has.
Where is that? Where is that? Show me.
That is also defective, and I shall substitute it because this is a transfer of I lost my sight. I do admit.
Why should the entry model continue then?
Stay operation.
This petition is
That is
out of
that.
An application under Order 1 Rule 10 moved by the petitioners, which has been rejected by the placed a regular for. Unfortunately, neither the plaintiff nor the order against which, judgment against which the RF has been filed has been placed on record, and necessary, other necessary documents are also not placed on record. An interim order of stay is operating since 2/12/2020. Matter is, but when the matter was heard, the letter counsel for the petitioner submits that you will file the necessary document. Let the petitioner file all the necessary documents within a week, subject to being a court approves 1,002.
Specific date may be fixed.
Bar Association. High Court Bar Association. File 1,000 cost to the Bar Association and file all documents. Yes.
45.
Matter may be taken up next week, my lord.
Why?
Matter may be taken up next week.
Is there any delay?
My lord, I have appeared, but no delay, my lord. There is an interim order. The suit for partition is being stayed. That is what?
Sorry, 46. 46.
This involves a short point also.
Which one?
This 45.
45. He's asking for a time.
Yes.
I am suffering an interim order. Let us short date be given.
Are you opposing?
Yes, my lord. Yes, my lord, I am opposing. I am suffering in my mention it has come, my lord.
Yes.
Both the suits are for partition, my lord. We filed a petition for analogous hearing of the both suits pending before the same court. That is what I could not prepare because of the short time.
But he is opposing what to do?
A short date may be given next week.
I leave it to your lordship. I leave it to your lordship, my lord. I am suffering. I leave it to your lordship.
So then this again, if he can't assist, what is the third way? Okay. Third is on the request of counsel. Yes. 46.
46.
Interim. Okay.
46, your lordship. This is last occasion that is ordered 23/2025, your lordship. They are directed to get the status of CMA number 35 of 2011.
Who is appearing for opposite party number 2?
I am there for the opposite party. I do not know whether my friend has received proper instruction from his senior, Mr. Lenka. He called me in the morning. He said, I'll not be there. I'll take time. That is fine. But let me also just, for your lordship's recapitulation, my lord, a petition under 151 of the CPC is pending for
Want to
recalling.
go ahead, then I'll hear it. Unnecessary, I'll not waste time.
No, he wanted a deferment, my lord. Now he's
Are you seeking an adjournment?
placing it.
My lord.
Huh?
My lord.
And he's placing it.
Learn counsel for the petitioner. Seeks an adjournment, the person is wrong. And the same was informed to the counsel, senior counsel, Mishra. In the morning, means the matter of 2 weeks.
Interim order may be
Interim order to continue. Yes.
47.
47, may I please, lord? Here, my lord, the case is that I have challenged the cognizance order dated.
Yes.
Order dated 10/7/2018, passed by the SDGM Koraput, my lord.
Yes.
On the matter relating to ID case, my lord. Section 29 of the IDA, Industrial Dispute Act. Here, my lord, I was working as a secretary in RMC, in the Regulatory Market Committee at Koraput. And there was a direction of back wages to the management in a industrial dispute case number 115 of 1995, and that was confirmed by the Honorable High Court in OGS number so and so. But here my case is that I have to disburse only 500, not more than 500. There is a backages of 27,000 some odd. But cognizance has been taken against me, my lord. Yes. As per the rule 25A of the Odisha Agriculture Produce Market Rules, but I have to pay not more than 500.
His power is that he can pay only up to 500.
Where is the award?
Award is
That is
annexure 1, a 2. 50% of the back wages.
Yes.
Relevant portion is page 29.
Page 29, my lord.
Yes.
And award calculated as at page number 30, my lord.
39.
30. Annexure 3 series. 30.
Okay.
Last portion. This is regarding the payment of annexure way back wages, back wages of Arun Kumar Mishra, Market Sarkar, the Labor Code, Jaipur has already
30 you already, annexure 3.
30, annexure 3. Yes, last portion. The wages of Sri Mishra as calculated from the bar at 1986 to 4/7/1996 may kindly be perused. Total wages of 55,616. 50% of that amount, 27.
30, page 30 something else.
Page 30 last portion.
30.
Last portion and page
30. There is something else.
I have also annexed that document. That is in my counter A/3. Annexure A/3. That is there in my counter. Opposite pad note 3 to 14.
A/3. Okay. Let us see A/3.
A/3. That is there.
Yes.
Yeah.
That is submitted there.
Yes. After deduction,
This is regarding the payment of loans.
Yes, sir.
Calculated to be 27,000.
27,808.
27,800 50% calculated. But as per the rule, my lord, volume on local volume on. Rule 25A, my lord. The secretary has only power to disburse only 500, but not more than that. Only have to refer the matter to chairman. And what I have done.
25
A, capital A. Last. I have marked it.
If there is an award, what is the problem?
Award is
not challenged. Award has become final.
No, award is challenged. Award is confirmed by this honorable court.
Yes.
In OJS number.
Then you pay the money for that.
No, I am not authority. I have no authority, madam. If the management, if a lordship direct to management.
If I'll dismiss, authority will come ultimately. 27,000. Why should I interfere?
No, my lord.
This rule that
It is the
It is the management who pay.
They let the management pay.
Your lordship direct to management.
You have implemented only
Yes.
him.
Opinion, no.
I am the chairman.
Management.
He has, as far
Who
as
is
from
implemented?
your lordships, he has erred that the management and other things in the opposite party, they are now.
Opinion number
The
3.
management should pay. I'll dismiss it.
No, yes, your lordship. Your lordship direct to management.
Your lordship will pass the cognizance order. I undertake to pay. I just want to show your
You
lordship.
come with the draft Monday, Tuesday.
Yes, your lordship.
Then
Your lordship,
you make him run here and there again. Come with the draft.
He have misappropriated a huge amount for that. Yes, I will.
But there is an award. It has been confirmed what to do. Come with the draft and give it.
Yes, yes.
Let
Your
it
lordship,
be little less.
I need
1
one
week
more
time.
time.
1 week.
I want some
Let
more
him
time.
come there with draft.
I want some more time, your lordship. Because it's
one
a
week up. 1 week after rako. Let him come with the draft and finish it. Pay it. I'll watch it.
Yes.
Very small amount. Why should I?
Yes, yes, I have.
Interim order to continue.
Yes.
No, interim order is there.
Entry order.
The lordships may reflect that they will form with the.
Shall I write it?
No.
Shall I record that you will come with the draft?
Not necessary.
Your lordship may not record.
It will create problem for him. You persuade your client.
Today I will inform them to prepare the.
Here.
Following the principles laid down by the Honorable Supreme Court,
Bichaka.
No, the Supreme Court, Supreme Court of
Order passed by the statutory authority on the same ground, criminal
Yes,
proceeding
yes.
cannot. That is the point.
Bichaka committee.
Radhesham Kejriwal's case of Supreme Court, that was the principles enunciated in that were followed.
Radhesham is different. Radhesham
No,
is
this,
adjudication proceeding. That's a different story.
Your Lordship, may I kindly see that.
What are the facts? Let us understand.
Facts is that allegation of sexual harassment was made. An inquiry was conducted on the POSH Act. The inquiry found that the allegations are incorrect, cannot be maintained, and they submitted a final report on the merits, absolutely on merits, not on technicalities. Now, parallelly, this proceeding under the various provisions of IPC has been instituted. There, my lord, the question arose whether two proceedings can go on simultaneously.
It is a statutory proceeding, there is no doubt.
Yes.
But can you term it as a adjudication proceeding?
That judgment, your lordship may kindly see. There's the Karnataka judgment, para 11, your lordship may kindly take. That is, they have considered all these aspects. Para 11 on this. This was also under the podcast. May I read one? In support of his arguments, learned senior counsel has placed reliance on the decision of the Honorable Supreme Court in Radhesham Kejriwal versus State of West Bengal. Reference to para 19 thereof would submit that the petitioners, having been exonerated on merits in inquiry held under the ICC, criminal prosecution on the same set of facts and charges cannot be allowed to continue as the standard of proof that is contemplated in an inquiry by the ICC is lesser than the standard of proof contemplated in a criminal trial. Disputing the submissions, respondent number 2, party in person, has taken me through the exhaustive material produced before the court and would submit that from the date of joining the company, she was subjected to unbearable harassment, which amounts to sexual harassment as well as harassment at the workplace. According to her, she has narrated the specific instances of harassment in the email as well as in the complaint lodged by her before the police and in the statement given before the police and before the learned magistrate under section 164 CRPC, wherein she has reiterated these allegations. And further, the investigating agency has also examined independent witnesses. Thus, she contends that there are sufficient materials to take cognizance.
Any other judgment you have?
14.
Because see, Radhesham and all, just now, today it will be uploaded. I have distinguished from Department of
Achha.
It's very
No,
detailed.
on merits, my lord, I have I have a case.
I may not agree with the
principles of
taken by Karnataka. See, the Karnataka last paragraph will come. 16 and 17.
Yes, well, 16 and 17 I'll read out. The facts narrated above, it's clear that an inquiry was conducted by the ICC in respect to the very same allegations which are now made on the basis of the criminal prosecution of the petitioner for the alleged offence under section 354A of the IPC. Even the material relied on by the ICC as well as the investigating agency is one and the same. Even though respondent number 2, party in person, has sought to justify the criminal action on the ground that the statement given by her under section 164 prima facie makes out the ingredient of the offences charged under the petitioner, I have perused the statement. Even in the said statement, except reiterating the very same allegations made before the ICC, she has not produced any additional material to substantiate the said charge. Nothing is there, nothing.
164 you have recorded?
Yes, Your Lordship. Where is I am addressing the court, the facts of the case, Your Lordship.
No. Have you examined 164 statement you have taken?
Yes, Your Lordship.
Can you show me?
Yes, Your Lordship.
And vis-a-vis the report of the committee.
IC report is
IC report.
Yes.
Vis-a-vis, just check it.
Yes, sir.
Identical, man. It's absolutely identical.
The 164 statement is very existing, Your Lordship. And also relevant page, Your Lordship, I have made pencil. I get into my pencil, Your Lordship.
When was it recorded? 8 and on the
IC0.
ICC report.
Page 70.
Page 70, kindly take page 82.
Where she has,
This report is dated.
and this is dated. May I submit one thing about, sir? Your
26
page.
July 2022.
Since 27/8/2021, the present victim, his lost 7 complaints were also before the authority.
That itself shows.
May I submit? Including her husband also lost complaint before the authority. They have taken any action on the complaint lodged by the victim and her husband. Thereafter, the victim lost FIR, Your Lordship. During lost FIR, thereafter inquiry has started. In inquiry, taking in the technicalities of different statement of the witness, the inquiry committing authority will exonerate the present petition, Lordship. My refusal, Lordship, the inquiry and FIR is the completely different, and the statement which are recorded, this is a case arising out of another previous case, Your
No,
Lordship.
don't say all this thing. You tell me.
Yes, Your Lordship.
The ICC proceeding.
Yes.
Is can be treated as an adjudication proceeding or a interdepartmental proceeding. You just tell me that. You answer me this question.
To that issue.
Can it be said to be an adjudication proceeding because it is a statutory proceeding. The statute, see the Bishakar regime earlier it was operating in the guideline. Now thereafter there is a act to that effect.
Yes.
And on the after the act came into force, the committee has got a statutory authority, and the statutory authority has developed the issue and exonerated. So it can be equated as an adjudication proceeding. If it is an adjudication proceeding as such, then the Kejriwal judgment benefit has to be given to them. If you say it is a departmental proceeding under the rules, then Kejriwal benefit they may not get. But if it is an adjudication proceeding, according to me, my view is it is an adjudication proceeding because it is a statutory authority.
And all members are
containing 7 members.
7 members, all independent.
Committee.
All independent members.
Lordship, to that effect, I have no doubt will satisfy, Lordship. First, whether the complaint lodged before the authority and the FIR is similar, identical, that to be seen first, Lordship.
Judgment will be approved. I'll put it on Tuesday. I just upload the judgment. Just see the judgment. I have dealt with. I have distinguished what is a departmental proceeding, what is an adjudication proceeding, and whether the exoneration in departmental proceeding will inure to the benefit of the accused for the purpose of quashing. I said departmental proceeding, no. Adjudication proceeding, yes. You have to equate this order, this ICC reports to a adjudication proceeding because of the nature. See, departmental proceeding, one single person inquires and gives a report.
No, that's
that
different.
is not equate. But here there 7-member committee.
7 members committee, cross-examination, examination,
and
everything.
This committee is constituted pursuant to a statute. A statutory backing is there.
An independent body also.
Independent body. So it is equate to an adjudication proceeding. You do it. It is a legal issue. I want to answer. Forget about this case.
Besides that also.
Forget about this case.
Also, looking at the fact of the case, Your Lordship, what is the, Your Lordship, that fact I will satisfy, Your Lordship. What is the FIR allegation and what is the complaint before the
everything goes.
report? That to be first, Your Lordship.
If the allegations are different, it's all right.
Yes,
allegations are correct, same sexual harassment, then it goes.
Yes, I am addressing from the fact of the case in the FIR allegation and inquiry, Your Lordship, report, complaint before the authority, Your Lordship.
See, otherwise what will happen is this exercise will be a futile exercise. Why this committee business? Why this committee business? The committee professor, it is kind of sanction, giving a sanction. Sanctioning authority, all the materials are placed before him. Then that is how. So that is the idea of this act. The harassment in the workplace has to be seen. So 7 members, see the presiding officer is a CVO and deputy director, and so many senior officers. And they are ladies.
Standard of proof in criminal case is higher than your
They,
lordship.
they,
That is your
they, they are not gents, they are ladies also. Before them, something has taken place, then today I will upload, just I will upload, just take it up. Oh, what will upload.
The Lordship may fix at 2 p.m. That's the other way, because even if they, besides this.
Only I need this answer.
That I will satisfy, but also, when this is a case, well, there is a second 482 application which is before your Lordship by the same petitioner. Another 482 application, your Lordships has allowed at the instance of this petitioner, wherein this very lady was one of the complainants.
Okay.
So multiple, they were a group of nurses, they were after the doctor. 7 or 8 nurses, they went after the doctor in filing one case after the other, like inside 7 complaints.
The same complainant has filed.
Yes.
That's what I have no idea for the time being.
And that has been quashed by your Lordship.
My case, I am addressing the
Get
court.
ready with that.
That's what I will also.
So even on merits.
After lodging 8 complaints, the authority is not taking any action, Lordship. That is there, your Lordship. 8 complaints, including her husband as well as complaint.
Who has given complaint?
A victim herself.
Before whom?
Before the authority, your Lordship.
Authority has conducted a.
After 8 complaints is given, thereafter the inquiry is held.
But inquiry is held. Now it's a very detailed inquiry.
No, intention is the report is, your Lordship is, report is technically has exonerated the authority, petitioner Lordship.
70, page 70 to 93.
Yes, I have, your Lordship.
And in page 80, very clearly said that I have never been sexually harassed. But
Pointedly, question put to her.
Page 80.
So making this statement, and this is July 22 or report.
82.
Page 82.
July 22 report and 164 is in February 22.
Yes, your Lordship.
Page 82.
Page 82, question number 9, your Lordship. Very pointed question, very pointed answer.
Question number 9. When did you feel for the first time that you are the victim of sexual harassment?
But there were question
I have never ever felt that I am sexually harassed.
Question number 10, your Lordship, page 82. Question number 10, your Lordship. She has given the dates, time, in the chamber, in the place. That not been
Does that amount, my lord?
But one
Even
answer
coming-
might not be
even
given answer.
taking
That
the
doesn't mean
statement as
another
the face
answer will be
value.
not taken into consideration, Lordship. Page answer question number 10. Page 82.
In the presence of 10 other persons. Even assuming that statement to have been made.
Do you have the statement of Nandita, Jena and
Yes, all this.
Vanita Paikrai?
We have the entire.
And they have stated that no such utterance was there. They have themselves
Question
stated.
10. He says that this incident happened on 12th of August 2021 at 4 p.m. to 6 p.m.
Yes.
In the presence of Nandita Jena and Vanita Paikrai.
Now kindly see
Let
page
us read
88.
their statement.
Now kindly see page 88. Page 88.
88.
Page 88, the paragraph at the top, last 4 lines. However, all the 3 witnesses denied such specific unparliamentary statement made by the respondent during this conversation as alleged by the aggrieved person. Therefore, this allegation also could not be corroborated.
Then that is also possible. You read it.
Wait, yes, I am.
It's a very detailed order, detailed report. So therefore, it is according to me adjudication, because I will have to equate this to as an adjudication order. Then the Kejriwal benefit goes, and the judgment which I have given, written judgment, that will also go to.
It will upload it today.
Today I will upload. Just
We'll be grateful.
I'll just upload.
Grateful.
Your Lordship will fix it at 2 p.m.
2 p.m. or 23rd or 24th?
24.
24th.
24th at 2 p.m.
A big loss of the mother case, Milord. Mother was starving. Milord. Let I wouldn't have Monday.
Which item is that?
61.
61.
61. We have your lordship has directed both of us. We have gone. Team of advocates. 4 advocates have gone. Social justice, Milord.
not today, but your lordship.
ତାକୁ ଡାକିଦେଲେ ବି ହୁଅନ୍ତା ସେ ଆସିକି ଏଠି ପଇସା ଦିଅନ୍ତା କଣ କରନ୍ତା କଣ
ଖାଲି ପଇସା ନିଏ।
କେସ୍ ତ ଆମେ
Blood with 125 is purposive is social justice. Mother is starving. Mother is starving with a Parkinson, suffering from Parkinson disease. My lord,
who is appearing for that Umakant Panda?
Myself.
What do you want?
I'm for the petitioner. Your lordship has directed me.
the handicapped person.
Who is supposed to pay the money?
My client. Your lordship has directed, therefore directed, if there will be explore to situation to compromise, that the mother can stay with the elder son. But we persuaded both elder son.
What is the name of the elder son?
Kalpataru.
He is creating problem. Huh?
Yes.
ସେ ବହୁତ ଭଲରେ ଅଛି ଆଜ୍ଞା ପୁରା ଏଣ୍ଟାର ମାର୍ବଲ ଘର ପୁରା ଏକଦମ ଭଲରେ ଅଛି। କିନ୍ତୁ କିଛି ନାହିଁ କାଲି ବାତ୍ୟାରେ ଉଡି ଯାଇଛି ତାର ଇଏ ଯେ ସରପଞ୍ଚ ଗୋଟେ ପାଲ ଦେଇଛନ୍ତି
କହିହବନି ମାନେ we cannot.
But he is not a party here, Kalpataru.
କଳ୍ପତରୁ is the petitioner.
Petitioner. I'm
କଳ୍ପତରୁ is the petitioner.
Yes.
Because your lordship has sent
So
me.
why
Because
don't you do it?
ସେ ଆଜ୍ଞା ମିସବିହେଭ୍ ବି ଆମକୁ କଲା ପରା ଯାଇଥିଲୁ ସମସ୍ତେ
ମୁଁ ଯାଇଥିଲି ମାନେ honorable court ର eyes and ear. I seen this. So I
What
cannot.
should I do then? You tell me.
Your lordship may pass any order and
I'll dismiss the petition with cost.
with heavy cost. Apart from that, my lord, of the
50,000
record,
rupees cost, go and pay the money to the.
my lord, and that should be your lordship may also say, my lord, since the elder son is quite able and the younger son is a disabled person, he is begging.
Umakant is disabled.
Disabled. So the learned trial court what has happened, share the amount.
What are you challenging here, by the way?
I'm challenging the only that
one
NBW was issued, distress warrant was issued for recovery of the amount. Of the matter, apart from that, since the report, you have prepared.
Show me the order. Show me the order. I'll pass the order right now. Show me the order.
And the maintenance amount should have been directed to elder son. Because this is a beggar, where he will. Despite that, the beggar son has also given the money.
7-10-24, my lord, page 12 your lordship kindly. That is the order.
7?
Page 12 your lordship kindly see.
Yes.
The order.
This is a petition under section 120.
My lord, 127, 128, my lord, for enforcement, my lord.
Enforcement.
128. This is a case under
What is the original order?
Original order that's not filed.
I have not
filed.
ମୁଁ ଫାଇଲ କଥା କରିନୁ ଆମେ
Show me the original order.
original order trial court record my lord. I have not filed only my lord ଏଥିରେ limited prayer କରିଥିଲି ଯେ ମତେ ଯୋଉ ଟଙ୍କାଟା ଏତେ ଟଙ୍କା କରିଦେଇଛନ୍ତି ଆସ୍ତେ ଆସ୍ତେ ଦେବି ଏଇଥିପାଇଁ ଗୋଟେ ମାଗିଥିଲି କିନ୍ତୁ now this issue is now because your lordship has sent me to
What is the
area my lord
36,000
36,000
only.
and in the meantime also more area has been accrued.
ତା ଭିତରେ ବି
You should have filed.
କେତେ ହେଇଛି କହୁନାହାନ୍ତି?
ସବୁ କରି କୋଟ କରିପାରିବି ମୁଁ କହିବା କଥା
24 ରୁ ଇଏ 3,000 ଟଙ୍କା ହେଲେ 12-13,000 ଟଙ୍କା ହେଇଗଲାଣି ପୁଣି
ନା ନା ପୁରା 125 ଦେଖି ଦେଖତେ.
First I am directing you to deposit 40,000 rupees.
ଆଜ୍ଞା.
Or I'll dismiss it with cost. I'll dismiss it with cost, that's the best.
Yes.
My lord, that is best.
But the problem is if I'll dismiss it,
ସେ
if he doesn't want to pay, he will not pay.
ଆଜ୍ଞା.
Then idea is the mother should get some money.
ଆଜ୍ଞା.
Yes, my lord. Therefore,
ସେଥିପାଇଁ ଆଜ୍ଞା ଆମେ ତ ହଁ
Straight away for
yes, ମୋର ପ୍ରେୟାର ଆପଣଙ୍କ ପାଖରେ ବି ସେଇଭଳିଆ ଇଏ ବି ଆସନ୍ତୁ ଗୋଟେ ମଡିଫିକେସନ ରେ ସେଇ ଡିଜାବଲ୍ଡ ସନ୍ କୁ ୱେଭିଂ କରିକି ୟା ଉପରେ ସବୁ ଯାକ
ଆପଣ କ୍ଲାଏଣ୍ଟ କୁ କହିଦିଅନ୍ତୁ 40,000 ଦବୁ ନହେଲେ ୱାରେଣ୍ଟ ହବ you will be arrested. You simply tell I'll pass that order.
yes and it may be lie over with lots. ତାହେଲେ my lord ମାଟା একবার ଥରୁଛି କାନ୍ଦ ଲାଗୁଛି.
These people don't deserve any.
ଭାବୁଛି ଆପଣ ଗୋଟେ ପାଥ ମେକିଂ ଜଜମେଣ୍ଟ ହେଇପାରିବ.
I'll pass a judgment.
Social justice because social justice notwithstanding matter.
First let us see the
my lord ଯଦିଓ education proceeding petition ଟା arise କରିଛି your lordship can pass order because social justice.
This is an execution petition.
ଆଜ୍ଞା.
In 125 proceeding.
First let the lady be secured.
Where is the original order is not there. Anyway.
Elcheta may be called for copy. Your lordship may call for the original.
Call for the call for. Petition is agreed by the order dated 4/5/2024 passed by the learned JMFC H. What is this H? H. क्यों जरा danger in CMC case number 125 of 2021, whereby the opposite party number, the petitioner has been directed to deposit 36,000 rupees towards the water maintenance in favor of the opposite party number 1. The opposite party number 1 is the mother of the petitioner. And the opposite party number 2 is the younger brother of the petitioner, who is an handicapped person. The matter was taken up on 27th, 3/2025, and notice was issued. So and so had an appearance, Mr. Das had an appearance. The matter was argued at length. It was brought to the notice of the court that the opposite party number 2, who is what it is, who is the mother of petitioner and the opposite
8
party.
years petty paka
Very old, and we
70
69. The opposite party number 2 is handicapped, and the court is not able to give support to his father.
Maybe Captain Doctor.
Petitioner is able person.
ଆରେ ସରପଞ୍ଚକୁ ବସେଇକି ମୁଁ ଡକେଇ କରୁଥିଲା
ଆମେ ଯାଇଥିଲୁ ଭାଇ ସବୁ
after hearing the parties, this court directed both the councils, requested both the councils for the parties to visit the place and visit the opposite party number 1 and submit a this is the report.
Yes, yes. Joint
Submit a report. The councils for the parties have visited the opposite party number 1 and have submitted the joint report. Joint report, which is taken under court. The report reads as reports to at this court records sincere appreciation to the efforts made by Mr. both the companies. Appreciation for the sincere efforts made by Mr. Bhavani Shankar Das and Saurabh Kumar Das. Regarding head to the report placed on record, I am of the considered view that the petitioner shall upfront deposit at least 50,000 rupees, at least 50,000 rupees to begin with, for the purpose of maintaining mother, namely the opposite party number 1. The deposit shall be made within 2 days. Within 2 days, reach the matter on 22. Pledging to deposit the amount by 22nd of April shall entail serious failing to deposit the amount is directed by 27th. Warrants shall be issued against the petitioner. The petitioner. The copy of the order be supplied to both the councils, scheduling for the parties to be communicated to the petitioner.
ମା କାନ୍ଦି କହୁଥିଲା ମତେ ନ୍ୟାୟ ମିଳିବା ବାଦ ଖୁସି ଲାଗିଲା
At least
ଆଜ୍ଞା
50,000.
Your Lordship,
ସେ କାନ୍ଦିକି କହୁଥିଲା କହିଲା ମତେ ନ୍ୟାୟ ମିଳୁନି
Lordship, kindly clarify the mode of payment methods. How he is going to pay? How the money will be paid?
ଏଇ କୋର୍ଟରେ ନୁହଁ ମତେ ତୁ
Petitioner should be present here and deposit here only.
ଡ୍ରାଫ୍ଟ
No. At the same time, this case is correct. Petitioner shall appear before this court.
Yes.
On 22nd.
with mode of
22nd. 22nd. And deposit. Let him
Big
come.
pardon,
Yes.
my lord.
Let him come.
Big pardon, my lord.
କହିଦିଅନ୍ତୁ ନହେଲେ ସେ
Deposit.
ବ୍ୟାଙ୍କ ଡ୍ରାଫ୍ଟ ଡିମାଣ୍ଡ ଡ୍ରାଫ୍ଟ
Before this court.
ଆଜ୍ଞା
ୟେସ୍
Let him come.
ଏଇଠି ଆପଣଙ୍କ ପାଖରେ କାରଣ ସେଠି ହେଲେ ବି ରିକ୍ସ ଅଛି
idea is that at least ladies
Equality will be secured. ma'am.
କାନ୍ଦୁ କହୁଥିଲା ମତେ ନ୍ୟାୟ ମିଳୁନି ଆଜି ମୁଁ ଖୁସି ଲାଗିଲା ଆପଣଙ୍କ ପାଖରେ ତାର
let him come.
Right. Yeah.